Yes. You can proceed.
I have filed a review petition on 6/7/26, Your Lordship.
Review petition?
Yes,
I have a criminal bench here.
no, Your Lordship order is,
Acha. My order.
Your Lordship, we are the messenger party, we have not been major party. That's why, Your Lordship, we have something to say, Your Lordship.
Acha.
Some record has not been brought to Your Lordship notice, Your Lordship. That's why, along with the IA, we have filed a review.
Okay, day after tomorrow?
Not a-
May I please, Your Lordship?
Yes.
I beg to mention item number 50, Lordship.
50.
50, adjournment for a day, Lordship.
Hearing.
Hearing, Lordship.
2019 revision.
Lordship, brief was lost, Lordship, and a certified copy was applied, Lordship.
Huh.
So, 1 week time, maybe.
Okay, 1 week's time,
Right.
not more than that. Okay, learned counsel appearing for the petitioner.
Petitioner.
Petitioner seeks accommodation in the matter and prays that the matter be taken up on,
1 week.
huh?
After 1 week.
This is July, right? And so list this matter on 3rd of August, right? More than 1 week, 3rd of August 2026. Since the matter relates to the year 2019, no further adjournment would be granted. And on the said day, endeavor will be made for disposing the matter.
Congress.
Wait, please, Your Lordship. I'm praying for an adjournment in item number 18,
1/8.
1A.
1 second.
Due to some personal emergency of the conducting council,
Hmm.
uh,
Okay.
so he is unable to present before this.
When do you want?
Day after tomorrow.
Day after tomorrow. Okay. Learned counsel Miss
T. Devi.
T. Devi, learned counsel Miss So and so appearing for the petitioner. Submits the matter may be taken up day after tomorrow. Prayer is allowed. List this matter accordingly on 29th of this July.
May I please, Your Lordship? Lordship, I beg to mention item number 23 and 24.
23, 24? Yes, AB.
Please, CD is not there, my lord.
Case day is not there? Okay, learned counsel for the petitioner. Seeks some accommodation in the matter.
They're in time.
Mr. MP Goswami, learned
DP,
AP, DP Goswami, learned APP for the state, submits that the case diary is also not available. As such, list this matter there is interim.
Yes, no, please.
List this matter on 13th of August. 13th of August 2026, interim order passed earlier shall continue until the next returnable date. In both the matters, interim
Yes.
orders are there. Okay, both the matters. are there.
May I please, Your Lordship?
Hmm?
I beg to mention item number 25 and 26. These are analogous matter, my lord.
Hmm.
It is called for, my lord, perhaps it is not available. So I
Acha.
have taken information
It is
from-
not available, Mr. DP? Okay.
They were on in time.
Interim in
Acha.
purchase, I am.
You are Mr. A. Islam.
MAI Hussain.
MAI Hussain, learned counsel, Mr. MAI Hussain, learned counsel for the petitioner submits that the matter be taken up on a later date. Mr. DP Goswami, learned APP submits that the case diary is not received. And as such, fixed this matter on same day, 14th of August. 14th of August, 11th of August,
My lord.
2026, interim order passed earlier shall continue until the next reasonable.
Highly obliged.
25, 26 both, huh? Yes, Miss Brown?
May it please your lordship? Your lordship, I beg to mention item number 48.
48.
48. We were supposed to file our additional affidavit, but due to unavailability of the petitioner, we haven't been able to. So your lordship may grant us 2 weeks' time, your lordship.
Okay, Miss M.K. Brown, learned counsel for the petitioner submits that she requires some more time to file the affidavit in reply,
Additional affidavit.
additional affidavit. And as such has prayed for some time, prayer is allowed. List this matter after 2 weeks.
Yes, your lordship.
List this matter on 10th of August.
Much
2026.
obliged. May please your lordship. Lordship, with the consent of the others, I beg to mention item number 16, lordship.
Item number
16.
16.
Yes, lordship. I'm appearing on behalf of R.S. Mishra, lordship.
Hmm,
Conducting counsel is out of station, lordship.
okay.
Can't find a list up to 1 week's, lordship.
Learned counsel appearing for the petitioner submits that the conducting counsel has some personal difficulty and could not come to the court today and has as such prayed for some time. Prayer is allowed. List this matter after 1 week, you said?
Yes, lordship.
List
Can you
this
be
matter
fixed on 21 August?
21st. You are there for the
Yes, I'm the
respondent?
respondent.
Okay. List this matter on 21st of July,
In August.
August.
Yes.
Okay, 21st of August. as prayed for by both learned counsels for both the parties.
May it please the Lordship, I beg to mention item number 28.
28.
Yes, ma'am.
Yes.
Matter may be adjourned for the day. My senior learner person can so lawyer out of session.
Okay.
We have
Uh,
not received the case diary also.
Case diary is there. So we'll give you only 1 week's time, okay? Because we will retain the case diary.
Here, Lordship, one thing, where a report was called for whether any case is registered against the petitioner or not.
Mm.
So, as per the report, Lordship, no case is registered against the petitioner.
So no case is registered. This case is not required. We can dispose it off. Okay. Because you can check your petition once more. Your prayer is whether any case is registered, but the report is that no case is registered. So no AB.
Yes,
You
sir,
don't
it's
have-
not available.
Mm.
Let his senior come, Lordship. Senior is
Otherwise, no apprehension.
no apprehension. Lordship.
Okay. Learner counsel for the. What will you do? You bring your senior today.
2 weeks after 2 weeks.
But then there is no apprehension. This matter could have been disposed of. Okay. Learned counsel for the petitioner submits that the conducting counsel has some personal difficulty and as such has prayed for some time. Prayer is allowed. List this matter on 10th of August, 2026.
Thank you.
You're withdrawing.
May it please the Lordship.
You know, learned counsel heard Miss.
I'm appearing on behalf of S. Munir,
Your name, please.
S. Khatun,
Learned counsel Miss S.
S. Khatun.
Khatun. Miss S. Khatun, learned counsel appearing for the there is allowed, matter is disposed of as withdrawn. Mm.
This is the sheeted case, Lordship, may kindly call for the TC.
Commercial one.
Commercial quantity.
Lordship.
Okay.
TCA may be called.
Heard Mr. M. Ahmed, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Ratabari Police Station case number.
My lord, special NDPS case.
Wait. Where is that? Yes, special NDPS case number 63 of 2025, arising out of Ratabari Police Station case number 99 of 2025, registered under section 22C/25/29 of the NDPS Act 1985. Call for the scanned copy of the trial court records. List this matter on 10th of August.
10th.
Okay, 2026.
He is also same, Lordship, translated case, commercial quantity.
Same. Okay.
Translated case, commercial quantity, Lordship.
May I please, your lordship?
Record may be called.
Co-accused bail petition is pending. LCR was called for. This matter may be tagged with bail application number 16.
Co-accused was released on bail.
Bail pending.
Pending, yes. Okay. We'll get that also listed along
Along
with
with,
this.
along with.
Okay.
Along
heard
with
Mr.
16, bail application number 1616/26.
Okay. While I dictate, you tell me the number. Okay, you right. Heard Mr.
Jat Hussain.
Jayad Hussain, learned counsel for the petitioner, and Mr. D.P. Goswami. By this application, the petitioner has prayed for bail in connection with special NDPS case number 52 of 2025, arising out of Pathargandhi PS case number 133 of 2025, registered under section 21C, same 2529 of the NDPS Act. The petition, it is seen that the charge sheet has been submitted in the instant case. As such, call for the scanned copy of the case trial court records. List this matter on 12th of August 2026. Learned counsel submits that the co-accused has also filed an bail application, and the same is numbered as BA
1616
1616.
public 26.
1616 of 26. And a prayer is made for listing both the matters together. Prayer is allowed. Registry is directed to list the other bail application along with the instant bail application on the said date. When is the date fixed there?
Short date may be given.
No, one was the that case, that is fixed.
Really, I don't know.
If you can set that date, I could have fixed that, this one with, along with that. So you give the date. You'll find it in the
Okay, it's good.
this thing,
Fine.
website. Okay, you give me the chapter date to huh? Okay.
Obliged, ma'am.
Yes, legal aid counsel.
Lordship,
Okay. You are the legal aid counsel.
a legal aid counsel.
How come this is filed through the legal aid? Like jail appeals?
The case was, it was filed in Petitioner Session Judge Court in Dibrugarh
Hmm,
for bail.
hmm,
It was rejected.
hmm.
Then they have sent the petition to the Legal Aid Council, District Legal Aid Council, to the High Court Legal Aid Cell.
Oh, that
High
is how
Court
it
Legal
is.
Aid Cell appointed me
For bail.
for bail, for bail.
For bail.
So 103
Yeah.
is there, call for a record lordship only.
This is what offense?
103 lordship, under section BNS.
Murder.
sir.
Murder.
Murder.
So let the case record come. Charge sheet is submitted.
Charge sheet, already final report has been submitted.
Yes.
Final report means charge sheet,
That's it.
That's it. yes.
final form.
Yes.
Okay. So let me call the records.
Yes,
Okay. Heard Mr.
Bani Das.
Mr. Bani Das, learned legal aid counsel appearing for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Chabua PS case number
70/2000.
70. Chabua, there are two PS cases.
First case was lodged by her. Under this case, the accused has named her name, mentioned her name in this
Acha.
statement under police investigation.
No,
Then
no, what
police,
is 69 and 70? There are two cases.
yes, 69 is the original case. That is the FIR lodged by my petitioner. That is
But that
accused,
is by this
Prohibitions
petitioner.
Barua.
Acha, okay. Proleka Borua. She
Prohibit.
has filed the first
Her
FIR.
husband was murdered. So then the accused, some of the accused has mentioned her name in the police
Mm.
police interrogation.
Now
Thereafter,
she has
police
become accused.
registered another case 70/2024 on 14th of September. On 15th September, she has been sent to judicial custody.
Acha, acha.
Till now, she is in judicial custody.
So
Now-
she is the accused in 70
7th,
in connection with Chabua PS case number 70 of 2024, registered under section 324 within bracket 4/103/03 within bracket 5 of the BNS 2023. It is seen that the charge sheet has been submitted in the instant case. As such, call for the scanned copy of the trial court records filed in connection with the aforesaid case. There also charge sheet is submitted?
Yes.
Both the cases?
Both the cases,
In this,
70.
in the petition of the sessions case number 350, probably 24.
Acha, you can say corresponding name
Yes.
within bracket sessions case
Session
number.
case report has been submitted, already submitted by me.
What is submitted?
The session case order,
Yes, the bill that has been rejected.
yes.
Okay, in sessions case number, number is what?
350, probably 24.
354 of
24.
24
Yes.
Yes.
of 24. So this case belongs to few years back. This 24, okay. Call for the scan copy of the case diary of the trial court records. Is this matter on 13th of August. 1960. Yes, Mr. Ahmed,
My lord, sitting on the call for.
city call.
And another with a fix on 13/8. Along with
There is another case.
another AV.
Acha, co-accused. Okay, so charge sheet, no. No charge sheet?
Not such.
Acha. Okay, heard Mr. J. Ahmed, learned counsel for the petitioners, and Mr. D.P. Goswami, learned APP. By this application, the petitioner has prayed for bail in connection with Colgasia PS case number 55 of 2026, registered under section 103/61 within bracket 2/3 within bracket 5 of the BNS 2023, corresponding to GR case number 605 of 2026. Call for the case diary. List this matter on,
13/8.
huh?
13/8 other.
Oh, 13/8. 13/8/2026.
Along with AB number.
Yes. The learned
AB
counsel
number.
submits that the co-accused has filed an application for anticipatory bail. The same may be tagged along with the instant matter, but whether that is required, but the same case diary.
Same case.
The same may
AB
be,
number 1591 or
and the said application is numbered as AB number
1591.
1591 of 2026. List accordingly. वो जो पहला वाला केस था ना, उसमें भी दे दो ना कि it is seen that charge sheet has been submitted. No. Yes, item number 6.
Wait, your ladyship.
Yes.
Your ladyship, I have a small manufacturing business of bell metal.
So you are praying for bail now only. What is 331?
House trespass.
Housebreaking,
House trespass. 305?
dwelling house, theft from dwelling house.
Uh-huh.
Theft from dwelling house.
Okay. Let me see the FIR.
Yes, ladyship.
He is inside since 18/7.
Yes, your ladyship.
Where is
Case
the
number 14, relevant part.
11?
14, your ladyship.
11 is what FIR?
11 is type copy, ladyship.
Uh-huh.
Type copy, ladyship.
Type copy, yes. Page number
14, ladyship.
14 is a part of the
FIR.
your this thing. Acha, you want me to see this FIR contents?
Yes. The brief of the case is that on 17/7/2026, complaint lodged in one FIR at this police station stating that on 15/7/16/7 at night, some unknown
And
culprits-
16. 2 nights.
Yes, between these nights.
Okay,
occurrences between
okay.
these nights.
Stating on between these nights. Okay.
Yes,
At
yes.
night, some.
Unknown culprits broke the lock of veranda in absence of the complainant's family and wrongfully entered into the house and stolen away 20 kg grass. It should be brass. An inverter machine, approx value 50,000, hence the case.
So grass machine.
It should be brass, your ladyship. They mistakenly typo error.
Brass.
Brass machine.
Brass and inverter machine.
Inverter machine.
What does
Ladyship,
brass
how I
means?
indicated in this case, ladyship,
Okay.
please come to page number, ladyship, my arrest memo, page number
Also,
80.
wait. At night, some unknown. So it was unknown.
Unknown, unnamed.
What about page 11? This is, you said, the type copy of the FIR.
Yes, ladyship. The SAR.
Same as her.
Same SAR.
It was given by Dujan Sharma.
Sharma, yes, this is Sharma.
It was his house.
Yes, ladyship.
Here, 12 pairs of bell metal disc and 20 kgs of bell metal and inverter machine. Okay.
Some
50,000.
then articles were recovered from their possession.
Acha.
Ladyship, how I come into this picture, ladyship, please come to page number 18, ladyship. Arrest
18.
memo.
Yes. This is the arrest memo.
Yes, ladyship. In the FIR, in the arrest, during the investigation, the police personnel, the investigation officer categorized the accused into two categories, principal accused and the other accused. If you see in that paragraph.
How many petitioners are there? Only one. Anup Bhuya.
Anup Bhuya, ladyship.
Mm.
What prompt here? It was revealed, Dipen Bhuya, page number 18, second paragraph. It was revealed, Dipen Bhuya, one of the co-accused, he is also not the principal accused, my ladyship, had received the stolen bell metal utensils from the accused Gunojit Talukdar, the principal accused, and subsequently sold the same to the accused Anup Bhuya, that is me. I have subsequently purchased the bell metal, two bell metal pot and one bell metal tray. Your ladyship, who is this Gunojit Dipen Bhuya? He is my next door neighbor, your ladyship. And we both are on the same business. He's also manufacturing bell metal. I'm also manufacturing bell metal. Your ladyship, one fine day, the police entered my house at around 3:27 PM, your ladyship, and they seized two bell metal pots and one bell metal tray, your ladyship. And they arrested me on the same day at night at around 7 p.m., Your Ladyship.
Mm.
The only allegation against me is that I purchased this particular bell metal from one of my next house neighbor, Your Ladyship.
Yes, you can be saddled with the responsibility provided you knew that those were stolen materials.
Your Ladyship, because
Your knowledge has to be there.
yes, Ladyship. But here, if I'm purchasing a bell metal from my neighbor, Ladyship, this is very common in our village. If somebody have extra, if they need a liquid money, they need cash, they used to barter this kind of things, Your Ladyship.
Yes, Mr. Goswami, if you
That-
knew that those were stolen articles, then of course some kind of a
That will reflect-
criminality will be saddled. But there is
that
no.
will reflect on the case because the several persons are involved in this case. So that may be an organized crime, Lordship. They have purchased and. So
But,
let the
okay.
case diary maybe call for a short date, Lordship. We'll try to produce the case diary, Lordship.
Ladyship,
Okay, I'll just go through this arrest memo. Wait. Yeah, following during the course of the assault, 6 principal person defined coaching one. So there were main 6 accused persons.
yes, Ladyship.
Dipankar, Chinmoy, Gunajit, and all that.
Yes.
Involved the theft has been involved in the theft of the arrested and respective roles in the commission have been surfaced. During the course of investigation, including you, she honored me and other accused persons to top on the should James and dishonestly received who didn't retain the stolen articles. This the Topon Deka, Dipen Bhuya, Pranab Roy, and Atul Das were not amongst the first 6, right?
No. Yes,
They are the receivers.
yes, Ladyship. And we are the subsequent receiver, Ladyship.
It was revealed Dipen Bhuya had received the stolen bill and accused Gunajit Talukdar from accused and subsequently sold the same to Anu. That is you. Accordingly, on being led by you, through material not being part of the stolen property, they recovered from your residence, so and so. Then, this disclosed that you had recovered articles from the principal in your reason to believe. But then it is alleged that you knew that those were stolen articles. Right.
It was.
This is where you come inside. Otherwise,
Yes, right.
purchasing something from somebody will not be a crime. But then you knew it is said. Of course, it is in the allegation.
Ladyship, but it is in a village, everyone in Hatyavari is in this bell metal in the business,
Mm.
Ladyship.
In page 32 of rejection order to learned trial court, Lordship, page 32, Lordship.
32.
Like, last para, Lordship.
Page 34
32.
or 32. Okay.
May I read, Lordship?
Upon careful.
Yes, upon careful perusal of the case diary, it further appears that investigation is still at a crucial stage. The investigating officer is yet to be recover remaining stolen properties, ascertain the complete chain through which the stolen article change hands, identify the role of each accused person, and collect further corroborative evidence, Lordship. The custodial interaction of this petition, Lordship, that's why bail petition was rejected because investigation was in initial stage. Who another
But
person
then
who were
this
involved-
custodial interrogation of this person's name is not given. So
It is
far
a-
as accused so and so, Dipen Bhuya and
I can, Ladyship, page number 28, Ladyship.
Given a short date,
The
we can
investigation
produce-
officer is paid for remanding accused person.
28.
Yes, Ladyship.
Hmm.
Here it is said ki they need the custody of only the 6 accused, but they didn't need the custody of the remaining accused, Your Ladyship. Even the police, they don't need our custody, Your Ladyship.
Where is it written? 28.
28, Ladyship.
Prayed for investigator.
No prayer for
officer.
police custody has been made in respect of the other accused persons, Your Ladyship.
Where is that sentence?
Page number
Oh, yes,
28,
yes, yes.
the second-
Yes, para, second para.
second
Okay.
paragraph.
Heard, mister?
Yes, sorry.
A. Sohoria, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Horthebari, Sarthebari, PS case number 69 of 2026, registered under sections 331 within bracket 4/305 of BNS 2023. The allegation against the petitioner the allegation against the, no, you're right. The FIR filed in the instant case was dated 17/7/2026, and it revealed that on the night between 15/7/2026 and 16/7/2026, some miscreants had entered the house of the informant and had stolen bell metal disc and inverter machine, which were at the cost of, no, which were valued at rupees 50,000. It is stated that during the investigation, the name of the petitioner surfaced, and it is stated in the arrest memo by the investigating officer that the stealing part was done by 6 accused persons, and that as far as the petitioner is concerned, he is stated to have purchased is stated to have purchased the said metal, purchased bell metal utensils from a co-accused. Full stop. It was further stated that on being led by the petitioner, 2 bell metal pots and 1 bell metal tray were recovered from his residence. It is also stated that the said articles were part of the stolen property, and that further the petitioners knew and had reasons to believe that the said articles were stolen properties. The learned counsel for the petitioner submits that the petitioner is no way involved in the said offense of stealing, as he had simply purchased the articles from one Dipen Bhuya. He has further placed the order of the Additional Chief Judicial Magistrate dated 19/7/2026, wherein it was stated that the investigating officer did not pray for police custody in respect of the petitioner and others. Mr. D.P. Goswami, on the other hand, Mr. D.P. Goswami, learned APP for the state, submits that the case diary would reveal the entire facts as to whether there are other accused, as to whether there is a chain of, as to whether there are accused persons involved in a chain of stealing and selling it to others, and who are the same. On consideration of the submissions made by the parties, more so in view of the fact that the said articles were purchased by the petitioner, and also due to the fact that the police does not require any further custodial interrogation, this court finds it fit that the petitioner be released on bail on furnishing of a bail bond of rupees 20,000 with 1 local surety of the like amount to the satisfaction of the Chief Judicial, what, satisfaction of the investigating officer on the following, under the following conditions. Those conditions, he will appear before the IO as and when called for. He will not tamper with the evidence. He will not influence the witnesses. He will not leave the place of residence without the permission of the investigating officer. Petition is disposed of. Hmm.
Without any informing us, my lord, item number 50 has been adjourned, my lord.
50.
Yes, my lord, that is a hearing matter, my lord, for last three.
He said he wanted only 1 week and then he is.
My lord, for last 3 occasion, he has done this thing, my lord.
In fact, I was reluctant because seeing the matter of 2019, and I said that no adjournment on the next date. That I have said. So next date is fixed. There should not be any adjournment because the matter relates to.
There, my lord, it will not be postponed, my lord, because they are.
I've said it will not be adjourned again.
Date was given, my lord.
And date was given. 3/8, not very long. Yes, Mr. Didas, you have some matter? 11. Okay, it will reach shortly. Yes. $27.
Yes.
Very good. 27 or list one. Okay. 27 or list one, so I can give any date. To me, Harry did yeah. On 12th of August. Undated Hogel 22. 12th of August. Item, no. Item 3. What your 1616 Thana? Yes. Yes.
There is a minor mistake in the order. It was a regular bail order.
Bail application on.
So the investigation officer was written.
Acha, it will be what? That
It'll be Aleka magistrate.
Huh?
CJM.
CJM. Acha, in place of investigating officer, you write CJM. CJM which place?
Barpeta.
Borpeta. CJM Borpeta. To the satisfaction of, CJM Borpeta. Okay. Yes.
My please, your lordship. Lordship, regular bail application, lordship.
Hmm.
In this case, lordship, I have been behind the bars in Central Jail, Tezpur, lordship, since 19 to 2026, lordship. As such, I have-
19-2.
19 lordship.
Okay.
Since, therefore, lordship, I have been behind the bars for more than 5 months, lordship. Lordship, in this case, the offences was registered under section 366A, lordship, initially, lordship.
So, kidnapping a minor.
Yes, provocation of minor girl, lordship. Kindly see page 29, lordship, FIR, lordship. Annexure 1, lordship.
Hmm. You have moved.
Saridwar police station.
You have moved me bail application before. All were rejected.
Lordship, rejected, lordship. Case was committed to the Honorable Court of Sessions, lordship. And during the time of committal coding, lordship, I was arrested by the strength of NBW, lordship, and on 19 to 2026, lordship. And thereafter, copy was punished, and thereafter case was committed, lordship. And thereafter, evidences of 7 witnesses recorded, lordship.
Examine.
Keeping me behind the bars, lordship. Lordship,
Now it is at the fake end of the trial. Oh.
Yes.
lordship. Lordship, kindly see, lordship, evidence of PW1, that is who is the doctor, lordship. This case.
Acha, I'll just go to the FIR first.
Lordship.
But you know that at the fake end of the trial, bail should not be, as a matter of course, allowed.
Lordship, the next
How many
is-
witnesses are left to be examined?
Lordship, next that is fixed for IO, lordship, and
IO only.
thereafter, lordship, question will come, lordship, 313 statements.
Those are okay.
And thereafter, lordship, evidence of DW's, lordship, and thereafter, lordship, argument, lordship, and thereafter, judgment, lordship.
No,
It's
DW
not a
will
short
be
time,
before
lordship.
313.
If lordship witness does
Oh,
not
no,
come-
after 313. Yes.
does not come on a day, lordship, again, I have to remain in the
That should be
jail,
okay.
lordship, for a long period of time, lordship. So generally it happens, lordship, witness does not come on a
Okay.
single day,
Let
lordship.
me see
And
the.
that's why, lordship, my prayer is there, lordship.
Huh.
Kindly see the evidence of PW1.
Your name is Konkon Sharma.
Yes, lord.
Only one?
Only one, lordship.
PW1.
Lordship, kindly see page, lordship,
Hmm.
page, lordship, 101.
Hmm.
This
Yes.
is the evidence of the doctor, lordship. Lordship, doctor's opinion, I am reading out, lordship.
Hmm.
Opinion, age of the person under investigation was above 18 years.
At what time?
Lordship,
After?
at the time of Lordship, examination of the victim, Lordship, immediately after the incident, the
But
victim
this
was medically
evidence,
examined, Lordship.
this evidence was taken this year
Lordship.
as the age was above 18 years. Acha.
Lordship, incident took place on 11/4/2020,
Three.
2013, Lordship.
2023.
Only after one
13.
day, Lordship, the victim was medically examined, Lordship. And the finding
Hmm.
is that, Lordship, age of the person under investigation was above 18 years.
Mm.
And two, Lordship, no signs and symptoms of recent sexual intercourse seen at the time of examination.
Mm.
Number three, the victim girl was not pregnant as
Mm.
per urine report and
Yes.
ESG pelvis report. No injury marks seen on any part of her body as well as her private person.
Mm.
Lordship, now kindly see
Mm.
the evidence of the victim, Lordship.
Okay, where is that?
That is PW7, page, Lordship, 114, Lordship.
Hmm.
Lordship, kindly see the
Hmm.
first paragraph of the evidence
Hmm.
and the first paragraph of the cross examination.
Okay, I'll read it myself. Wait.
Yes, Lordship.
Informant is our uncle?
Yes, Lordship.
Oh, informant, yes.
Yes.
Okay, a case for bail,
Doctor's
in fact,
opinion
case
is-
for acquittal.
Lordship, doctor's opinion is fully corroborated by the evidence of here.
Okay, what do you
By the
say,
victim,
Miss
Lordship.
DP, Mr. DP Goswami, what she said is, in her examination in chief that she was 17 years.
Yes.
But in her cross-examination, she said that no, I'm more than 18 years.
Okay.
And then she also said that I was having a relationship with the boy, with the accused person.
Yes.
And the accused person had taken her to his house and he wanted to rape her. But then when she said not to rape her, he did not. And then on the next day, when the police went to his place, he told her to go behind something. She went there. So it shows that there was a
Understanding is there.
relationship and yes,
Understanding between the parties is there. Understanding
yes.
between the parties. is
And
there.
ages also has to be proved in the trial court.
Yes. Now, Lordship,
Only-
since the evidence of the victim has already been recorded, there is no chance at all to influence the victim, Lordship, since evidence
Okay, okay, I'm allowing bail. Third, Mr.
of A.K. Ahmed, Lordship.
A.K. Ahmed, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Sessions case number what?
97 of 2026.
Case, what? Sessions, where is that? Sessions case number, you have not put it in the
First title, Lordship,
Sessions
page-
case number?
Page 2, Lordship. First title, page 2.
Yes. GR case number, no. Oh, yes.
Earlier it was
Sessions
GR
case number 97 of 2026,
Lordship.
pending before the Honorable Court of Session Judge Sonitpur. It is the case of the petitioner that an FIR was lodged on 12/4/2013, revealing inter alia that 2013, filed by the uncle of the victim, stating inter alia that the victim, who was 17 years of age, was kidnapped by the accused person, allegedly kidnapped by the accused person on 11/4/2013 at about 11 p.m. from her house. On the basis of the said FIR, a charge sheet was submitted, and after completion of the necessary formalities, the trial commenced. During the trial, the witnesses of how many persons were examined? You said seven.
7 witnesses,
During the trial, 7 witnesses were examined,
including the victim.
including the victim, and that the IO, the investigating officer, is yet to be examined. The learned counsel for the petitioner submits that the that the medical examination of the petitioner done on which page you said 100 and done on the next day of the incident revealed that the age of the victim was above 18 years and that there were no symptoms of recent sexual intercourse were found. He has also placed reliance on the statement made by the victim before the trial court, wherein she had stated in her cross-examination that she was more than 18 years of age and that she had made an incorrect statement before the magistrate that she is 17 years of age. She also stated during her cross-examination what did I say? A cross-examination that the accused had tried to commit rape upon her, but when she asked him not to do the same, he had restrained himself. Full stop. She further stated that she was taken to different rooms by the accused person, and that when the police came on the particular day, the accused person told her to go behind the washrooms, to which she did, and she further stated that the police had recovered her therefrom. He as such submits that the victim was not minor and that she had relationship with the petitioner, and in pursuant to the same, she went to his house voluntarily. On the other hand, Mr. D.P. Goswami, learned APP for the state, submits that the victim, in her statement before the trial court, had specifically stated that when she went out of her house to attend to her nature's call, petitioner came and forcefully took her from his house. And as such, he submits that the offense under section 366 is meted out in the instant case. Para. On consideration of the submissions made by the parties, more so in view of the statements made by the victim in her cross-examination, this court finds it fit that the petitioner be released on bail. Full stop. It will not be out of context to mention herein that the trial is at the stage of conclusion, and it has been held by the Honorable Apex Court that at the fag end of the trial, bail should not be given as a matter of bail should not be normally allowed. But in the facts of the instant case, this court finds no, it is in the facts of the instant case, it is the considered opinion of this court that the petitioner be released on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the session judge Sonitpur. Under the following condition, the petitioner to appear before the trial court as and when called for on each and every dates. The petitioner not to temper the evidence of the case or to influence the witnesses or to go near the victim at any point of time. Petition is disposed of.
Much obliged.
Yes, Mr. Rekha.
My lord. Pray for calling for the CB.
Yes, what is the offense? 64K is what? 2K?
For committing rape upon a man who is mentally
Or
unstable.
physically disabled.
Let the case diary come.
Yes.
Heard, Mr.
Be Bora.
B. Bora, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Gulabganj PS case number 114 of 2026, registered under section 64 within bracket 2 within bracket capital K /296/351 within bracket 2 BNS 2023. Call for the case diary. No charge sheet, right?
No.
No.
Call for the case diary. List this matter on 11th of August.
May it please your lordship.
Mm.
Lordship, this is a regular bail application, lordship. Here the father and son, lordship, booked for purchasing, lordship, stolen brass metal, lordship.
Oh, again,
They-
same thing
Yes, lordship, but.
as the earlier one.
But the.
But there the facts are different.
Here also, lordship, I have a lordship, kindly, may I take a lordship, page 25, that is a trade license, lordship. We
25.
have a shop, lordship.
But the same case.
Not same case, but a similar nature,
Acha.
similar nature.
Patasarkosi PS.
Uh-huh.
It is Patasarkosi PS.
That was what?
That was
That was
That was called by chief.
Hortebari, yes, yes.
Now,
Yes.
page 25 is the lordship, trade license lordship, we have a utensils shops lordship.
Acha.
It is issued in the name of the petitioner number 2 and father used to sit in the shop lordship. What happened lordships, now lordship kindly come to the page 13.
Bhai Boshanaloy. How do I make out that it is a it is for a shop of brass metals?
It's a basan lordship, basan's a utensils.
Boshanaloy.
Yes, lordship.
Okay, then
It's a issue to the name of the petitioner lordship, number 2 and father is the petitioner number 1 lordship. Now lordship will find the FIR on page 13 lordship.
Acha. Petitioner number 2 is Rashidul.
Rasidul.
Rashidul. It grants to Rashidul Islam.
Yes.
Son of Hajrat Ali. Okay.
Hazrat Ali is the petitioner number 1 lordship.
Acha. Where is the FIR?
FIR that is on page 13 lordship. He has no knowledge lordship. It is admitted lordship. They have purchased this lordship, material lordship. Only the lordship 411 is against this person lordship and the punishment is 3 year lordship.
They knew that those were stolen articles.
They have no knowledge lordship. On bona fide village lordship, they have purchased because in that shop lordship, people used to lordship exchange the old brass metals with the new one lordship. That is the thing lordship. Sometimes people borrow money against the utensil lordship. Here lordship, FIR on page 13 lordship.
11. Translated part.
Yes, lordship. And lordship, this is a recovery already made pressure cooker from this petitioner and that lordship. I have that. Xerox. Can be kept as a part of record lordship.
Okay. I'll just go to the FIR first. What is this?
It is on
FIR
page 13.
was lodged by the person.
Manoj Kumar Deka.
It is from his house, the articles were
It's from
stolen.
Namghor.
Namghor.
Oh, church. Occurred in Sri
On
Modern
Haithan.
Haithan. On the next day, 8/7 at about 6 a.m., Namghoria of the metro. Village entered the Namghor and found that a
All the persons who were arrested, lordship.
Acha, wait.
Recovery already
One
been
second.
made.
One second. He immediately informed the president. Responded and he had stolen a CCTV camera. And pressure cooker and it's an automatic box. Okay, then
Recovery lordship, I have given the flag mark lordship, only recovery that was pressure cooker and 15 brass metal lordship, that is it.
rented go down of Hereby
Flag mark
search
is the lordship from the petitioner lordship,
rented godown of Ripon Chandra Paul. He's someone else.
someone else.
And seized the following godown on connection with the above. 50 pieces of 11/7, right? 11/7. 50 pieces of broken horai made of different sizes. 8 of broken horai. And 3 numbers of water storage, glass metal, tar, silver, silver.
The flag mark lordship indicating recovery from this present petitioner, Hazrat lordship.
Okay. Otherwise, it was first one is from the godown of Ripon Chandra Pal. The second one is the rented house of Pilbar Ali. So many things, right? From the possession of Hazrat Ali.
Yes, lordship.
So it will confirm the case diary also whether they were aware of the fact or not. lordship.
They have lordship, that is not their lordship. We have admitted in our petition lordship and the trade license, the person having a lordship, shop lordship, definitely they will not go for all these things lordship. Yes, lordship admitted they have purchased it from the person lordship, whom they are not known lordship. They have come lordship, usually this person lordship exchange their material lordship. Considering lordship 16 days and recovery already been made from this petitioner lordship, nothing further will come against this petitioner lordship. They are not committed any theft because theft was committed by unknown person.
But it is not written that they had purchased it.
I have admitted in para 6 lordship, I have admitted in my petition lordship.
On that case, it was reflected in the trial court order lordship. Other case.
We have approached straight to this court lordship. There is no required lordship stolen.
Where is the
Para
trial
six-
court's order here?
Para 6 lordship in page 5 lordship.
You have written that those were purchased, right?
Yes, lordship.
What about the lower court's order?
We have not approached the court below lordship. It's a
Acha.
state approach. Lordship, only 16 days in jail custody lordship, recovery already been made lordship. That's
Okay,
why
when a
lordship,
short
we are
delay to
considering
what
the
is the
length
case
of
diary?
detention lordship. Nothing will come against this petitioner lordship. Because recovery, whatever recovery has to make, that has already been made lordship. And other recovery lordship that is specified in that is from Ripon Pal and other person lordship.
Several persons were involved in this case.
Lordship, now the formalities lordship, custodial integration lordship.
What is there in the forwarding report?
Forwarding lordship will find on page type copy on 17 lordship.
Anything specific about the petitioner?
No lordship.
No, lordship. During the investigation, the accused persons were identified, apprehended, and stolen temple articles were recovered from their possession.
And moreover, 35(3) notice was not issued lordship because the punishment is 3 years lordship. If they purchase this material lordship, that was not even lordship discussing the forwarding report also lordship. Why they have not issued the 35(3) notice lordship.
I prefer case diary also only.
Considering length of detention lordship, because no further custodial interrogation was sought for lordship, only common specific that is on police remand, 5-day police remand for accused person, not specific against this accused person.
No, accused person, the chart is given in the first page.
But
So all
we
are
have admitted
included.
lordship, we have a trade license lordship, that is a annex, that's why lordship.
No, what I'm thinking is if you abscond, then
Any condition, any stringent condition lordship,
it's okay.
any
but-
stringent condition lordship.
But it happens,
the
Mr.
trade-
Goswami, what happens is many shops, they buy those stolen articles.
Yes, lordship, but whether they were knowingly or unknowingly,
That
that
is what
Definitely unknowingly lordship.
has to be seen.
is they were doing it without the aware of the fact, lordship, then it's a
Had I not been a shop lordship, that it would presume lordship that.
This person's name might have figured on these statements made by some co-accused
Yes,
perhaps.
lordship.
And
Yes.
He
there are
must have said that we have sold the items there or
Yes.
there are
those
several,
facts are not there, right?
But
Not
lordship,
in the
they-
forwarding.
yes, lordship.
there are several shops are there, lordship, whose
That's
only
why.
purchase stolen properties.
That's why lordship.
Oh,
I placed the
God.
lordship. That's why lordship I placed all the scissor lordship recovered from whom.
Okay, Heard Mr. B. Chaudhary, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with uh, and shall read Patachar Kuchi. Okay, PS case number 100 of 2026, registered under section 305/331 within bracket 3 of the BNS 2023. It is stated in the FIR it is stated in the FIR dated 9/7/2026 that some unknown miscreants had stolen various articles from the Sri Madan Mohan Guhai Than on the night of 7/7/2025. Full stop. It was also stated that when the Namghoria of the Satra entered the Namghor on the next day, that is on 8/7/2026, he found various items being stolen therefrom. And an information was given to the police station. The police registered the case as mentioned above, and during investigation, the police had recovered and seized the articles from various places. One of them being the shop of the petitioners. Learned counsel for the petitioners submits that petitioner number 2, petitioner number 2 had a trade license for running his shop known as Bhai Bhai Bashonaloy. Bashonaloya. And that his father, in the name, shop boli koise na? Shop. And wherein his father, that is petitioner number 1, also sits. The learned counsel submits that the petitioners had purchased the articles without knowing the fact that those were stolen articles. He submits that 4 numbers of broken, damaged, horizontal stand of different sizes. Broken, damaged horizontal stand, which were there in the hot drawer. Okay. What did I say? 4 numbers of stand of different sizes, comma, 1 medium-sized brass metal dish, and 1 pressure cooker, Surya, and 1 pressure cooker were seized from the petitioners, were seized from the possession of the petitioners. He, however, submits that petitioners had no knowledge that those articles were stolen articles. On the other hand, Mr. D.P. Goswami, learned APP for the state, submits that the case diary of the instant case would make the things clear and would show the complicity of the petitioners and others in the aforesaid offense. Full stop. On consideration of the submissions made by the parties, more so in view of the fact that only broken and damaged articles of different sizes were seized from the possession of the petitioners, along with 1 medium-sized dish as well as 1 pressure cooker. From the petitioners who had a shop involved in selling and purchase of articles. This court deems it fit to release the petitioner on bail on a on a or on furnishing of bail bond of rupees 20,000 each with one local surety each of the like amount to the satisfaction of
CGM Bojali.
CJM Bojali under the following conditions. Say they will appear, they will, no charge sheet, right? Yes. They will appear before the IO as and when called for. They will not tamper with the evidence, neither influence the witnesses connected with the case. And they will not leave the place of jurisdiction without the permission of the said court, CJM Bajali. Petition is disposed of. You can take this, your Caesar list. Mr. Chaudhary. Mhm.
Okay. My business, Lordship.
Mm.
Miller, there are two affairs, Miller. The first affair was closed by the petitioner, Miller. This was registered and as Avaivari PS case number 160, Miller.
Acha, that was filed by the petitioner.
Petitioner.
Then,
Miller, and after 4 and 5 days, the accused, the informant lodged this FIR.
who had lodged?
Miller, the relative of the FIR number 172. Miller.
So what is,
FIR is Miller, page number 9.
what is the offense? What is the offense?
Miller, offense is Miller, this unlawful assembly, criminal intimidation,
Is it?
uh,
Injury?
injury. Petitioner 1 is admitted in Warpata Medical College.
Fight amongst two parties?
Yes.
Acha. Show me the FIR.
Miller, page number 9, Miller. It is translated settlement.
I'll read it myself, wait. What is your name? Chakker Ali. Oh, so many.
Page 15 is the impugnator.
Page 15. Okay, let me see
Unit.
the name of the petitioners. Okay, these are the, page 15 is the FIR against them.
Them.
Page 15. Okay, this is the FIR against them. So overt act against three persons, 1, 2, and 3. 4 and 5, okay, there are no overt act mentioned in the FIR, specific act, right? With respect to 4 and 5. So what, this FIR was lodged on 7/7. This is the cross FIR.
Cross affair.
Miller, 7,
What is the timing here?
But Lordship will kindly
Miller,
see,
page number 14, Miller.
their FIR, Lordship, the impugn FIR is 172. And
Huh?
the FIR which was lodged
Hmm,
by them, it is 160. So that was prior in time, Lordship.
160.
Yes.
Numbering comes that way,
Yes,
serial
yes,
number.
Serial number 82.
Anyway, 7/7, information received at PS is 11/7?
This is the second FIR, Miller. This is the counter blast, Miller. You said there is skins, Miller.
But the FIR, I think, against you
Yes, Miller.
was later in point of time.
Later.
11/7, see,
Eleven-
Mr.
Yes.
Bosha?
Yes.
Yes,
Yes.
yes.
That's what I pointed out. Lordship.
Huh, so that was lodged on 11/7.
Yes, Miller.
Yes.
Page number 14, if it is the continuation, if it is the first.
FIR number 170, my lord.
FIR number 172.
My lord. Date
So
of
this
time-
information was received on 11/7, Mr. Sharma.
Yes,
And the time is 21/8, means late
Yes.
at night.
that is why Lordship, the number is 172.
But the FIR that was lodged by him,
Yes.
that is earlier in point of time.
Yes. Yes.
Yes, 60. That is what you said. Yes. There are 12 accused persons. I have been informed by my husband, Chakil Ali, working as a contractor in Mizoram. When he returned, one day he went to Man Bazaar and met accused number 1, Bakkar Ali. Bakkar Ali. So Bakkar Ali is the husband of the informant of the second FIR?
Yes,
Yes.
Bakkar Ali.
Bakkar Ali is the
Husband of Salima Khatun.
Yes. Accused number 1 in the FIR.
Huh.
Bakkar Ali, Yes.
Bakkar Ali.
Yes.
Bakkar Ali, yes, ma'am. With the niece, my lord. Brother's daughter, ma'am.
These are all relatives.
No, my lord. And we have. we
Wait
lodged
1
the FIR.
second.
They were
Accused number
absolutely-
1 hired my husband's
Later on.
company use for election work. On 6/7, my husband demanded a remaining outstanding payment from number 1. The accused person abused him with sign language and also told him that he will not pay any money. After some time, the accused person called for person 3. Budhi Ali and the assaulted my husband punching him so on the same day when my husband was doing on the young person.
Informant is the FIR,
1 year.
wife of the
Huh.
number 1 here. Lordship.
I know. So two different stories.
Two different stories.
Wife of the first FIR, she says that my husband was working in Mizoram when he was
Yes.
coming back and was asking for his vehicle's
Yes.
money. He was attacked. He says that when he went to the market and all, but anyway, this FIR is later at point of time. So
Even if you go by the FIR, Lordship will see that here it speaks of some treatment been going on for the
Mm.
petitioner number 1.
mm,
So in that view, the matter, in that FIR, Lordship, there is nothing of under treatment or anything that is not there in the
huh, it
FIR
was
against him.
immediately lodged on 7/7.
That is why, Lordship. Let them.
Incident happened in late night, so let them go on bail. It's a group fight. I don't know why.
Lordship, when the CD comes.
Mm. This is AB, right?
Yes, Lordship.
Okay, let you be an interim and the CD come. CD is required or finally I can.
Lordship, let the CD come because we'll examine the medical report. If there is something, then
Okay. Heard, Mr.
Yes, Islam, my lord.
Islam, learned S. Islam. Mr. S. Sahinur Islam, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. The FIR lodged in the instant case was dated, was dated 7/7/2026. But it has been, it was registered by the police on 11/7/2026. And the said FIR reveals that while the husband of the informant went to the market, the accused person, that is petitioner number 1, 2, and 3, 1, 2, and 3, right? Petitioner number Chakir Ali, Chamer Ali, and Razab Ali. Okay, 1, 2, and 3. Oh no, accused number 1, that is petitioner number 1. Was alleged to have forcefully snatched away rupees 50,000 from the pocket of the informant's husband and assaulted him. It was also alleged that in the meantime, the brother of the informant went to the place of occurrence and he was also beaten up by the accused persons, that is the petitioners. It was further stated that after a while, all other accused persons, that is the petitioners, returned again by carrying weapons in the house of the brother of the informant, and that the informant side were beaten up and the women were also harassed. The learned counsel for the petitioner submits that the petitioners had lodged the ejahar on 7/7/2026, immediately after the occurrence, alleging that 12 numbers of accused person, including the husband of the informant of the subsequent FIR, assaulted the husband of the informant, that is, assaulted the husband of the informant on the ground that the informant had lent his, that the husband of the informant had lent his vehicle for the election work of accused number 1, that is Bakkar Ali, and while returning from his work from Mizoram, the accused persons had attacked the husband of the petitioner. When the husband of the petitioner had asked for the money from accused number 1, that is Bakkar Ali, the learned counsel for the petitioner submits that it was the petitioners who were attacked by the informant side, as is revealed from the FIR, and that the FIR against the petitioners were filed after a number of days. And the said story set up in the said FIR was a hooked up story. Mr. B. Sharma, learned APP for the state, submits that the FIR lodged against the petitioners were later at point of time, and the FIR lodged by the petitioners against the informant of the FIR lodged by the petitioners were earlier in point of time. I have considered the submissions of the parties and have seen both the FIRs, and this court finds it, and in the said facts and circumstances of the case, this court finds it fit that the petitioners be released on interim pre-arrest bail on furnishing of a bail bond of rupees 10,000 each with 1 local surety each to the satisfaction of the investigating officer under the following conditions. So and so, ekini diba, call for the CD, list this matter on 19th of August, 2026.
Madam, my one submission is that, madam, both the city of the 2 affairs may be called for me.
Is it?
Then
Okay.
will be clear.
Yes, the case diary of both the
Obhay-
cases
Obhay
being
160 and 172.
170.
being what case numbers you just said?
160/26 and 172/26.
160/26, 172/26, of which police station?
Bhaipuri.
Abhayapuri police station.
Yes.
Abhayapuri police station. Okay.
I know.
Yes, Mr. Das. Some tender matter? FIR?
This is a tender matter where FIR has been filed.
Ah,
I don't know, my lord, why this has been filed. Work order at page 19, please see, work order.
hmm,
Letter of acceptance is at page 18.
hmm.
18 is the letter of acceptance. Please mark, my lord, subject, water supply project including 5 years of O&M maintenance.
Hmm.
Now, please see at page 19, this is a work order.
Hmm.
Now, if you see the IFB,
Hmm.
it's at page 21.
Hmm.
21 is the invitation for bid.
Hmm.
If you see on the right-hand side, period of completion of 2 years,
Hmm.
but there is a provisional, my lord, extension of the work order.
Hmm.
Please see, this is very important.
Hmm.
Take on work. Work order has been extended.
Hmm.
Please see, it is by virtue of 5th of June 2026.
Hmm.
Because we could not annex, I asked them to bring it. This
That's
may be important.
Hmm.
Your lordship may ask that why 2000, it's written 2 years.
Hmm.
If it is 2023, 24, 25.
Hmm.
Now, that's why it has been, please see, you are hereby directed, you see the letter, to expedite the progress and make all necessary arrangement to ensure its commissioning at
Hmm.
the earliest. So there is no commissioning
Hmm.
of this project. Now, please see at page IFB terms and condition, this is important.
Hmm.
It is extended till 9/9/2026 by the order.
Hmm.
Please see at page 34.
Hmm.
Please see 34. Please
So this
34.
project will take around 6-7 years.
That's the problem. Maintenance, total.
Maintenance, okay. Maintenance.
Maintenance, inclusion of commissioning and maintenance, total.
So, Dhekiajuli town water supply project. This
Yes.
is water supply,
Yes,
including 5 years maintenance.
yes, maintenance. Now suppose
Huh.
there is a breakdown. Suppose it falls down, something it happens. Then this maintenance is our part.
Hmm.
So it is not that you lodge an FIR and say that this has broken, one part is broken. So this is what we are trying to bring with the ambit of this, of the BNS. How can they do it, man?
Now, what is the criminal aspect? I didn't get it. What happened after
Criminal
this?
aspects in the FIR.
So maintenance and all, even installing is extended.
Yes, what they have done,
Huh.
my lord, your lordship knows that before the election, whoever the MLA or they will try to say, oh, this has been commissioned.
Hmm.
I have not heard a word partially commissioned. Can be a partially commissioned. Please see the FIR at page 12. What partial commission? I don't understand.
Hmm.
Please see at page 12.
Hmm.
A second paragraph, the word, this is a JV, my lord. I am for the JV.
Hmm?
JSEE. Please see at page 12. JSEE.
Janjeer and this.
JV.
JV?
Manoj Talukdar dash JSEE JV.
Hmm.
My
This is the place or name of the place.
The name of the company JV.
Oh, the
JSEE.
company.
Yes. Now the project, see the was partially commissioned on 9/3/2026.
Achha,
However,
I'll just go through the entire one.
yes, please.
FIR regarding collapse of elevated service reservoir
Yes.
of Dhekiajuli.
Waters-
Dhekia or
Yes.
Dekhijuli water panamara under Amrut.
Yes.
Okay. I would like to inform you that
Inform
one
them
project
so
is
as
being
being
implemented
implemented
under
under the execution of project by entrusted Mrs. Manoj Talukdar, JSO and so JB. The contract of carrying. The project was partially commissioned on 9/3/2020. However, on 17/7 at around 3 p.m. so and so, constructed under the project collapse of Dhekiajuli town. Collapse of a newly constructed public utility structure within a few months of its partial commissioning has caused serious concern regarding the quality of construction, workmanship, adherence to approval specification, compliance with the prescribed engineering standard leading to doubt to breach of contract.
Hmm.
The incident has resulted in substantial damage, public and adversely affected the complementation of the completion
implementation, I think.
of the water project and has brought serious embarrassment for the mission of the water supply project, has brought serious embarrassment for the mission as well as government of Assam, the misuse of government fund. In view of, I am lodging an FIR so and so to investigate the matter.
Hmm.
Now,
Achha, the reservoir has fallen down.
yes,
And
not-
yes.
part of it has fallen down, not entire part of it.
Mhm, mm.
Part of it has fallen down.
It is
No.
not written part of it.
No,
However, on so and so at around the elevated Jinkla Loom elevated reservoir under the project collapsed.
we have mentioned
Hmm.
in paragraph 4, my lord. Please see,
Hmm.
only a portion at paragraph 4, my lord.
Achha.
We have mentioned specifically. All
But
are
it is a serious concern. I mean, these whatever bridges, buildings,
No,
they all fall down at one point of time.
my lord, kindly see. Let's see the instance of the Chanmari, this bridge. Why all this, my lord, the repairing is going on.
Mm.
Kindly see, lot of accident has happened. That doesn't, my lord, it doesn't.
That was not completed even and they opened it.
Then, my lord, please see, what I don't understand,
Hmm.
it has been given to a contractor.
Hmm.
All the terms and conditions of contract, if there is a violation, of those terms and conditions that will lead to the terms and condition which is laid down. Either there will be liquidated damage or whatever. My lord, suppose the public, somebody has fallen down. In Mizoram, I know when I was in AG, my lord, someone's slab has fallen down. Then no injury, nothing. Then there was a PIL which was lodged. One part, it fallen down. My lord, here is a case, kindly see, my lord. It is a project which has to be completed. Partial commissioning, there is no partial commissioning as well. I have to
No,
complete.
partial commission, what they mean is installation, maintenance, installation should be over.
No, that is not over. My lord, if that be the case.
But the reservoir was placed and it is over.
No, my, please see. This is only a test run. Please see.
Acha.
This is our test runs under the terms and conditions. There will be a test run. Please see at page 36. This is, once it is complete, then it will be a test run at page 36.
Oh, the project is not complete as of yet.
That's the whole problem, my lord.
Acha.
That is why at page 5th of June 2026, there is an extension of the project. I could understand all complete, OM is complete. Please see 2026.
No, your extension is still 9926.
Yes, that's it.
And 9926. And this FIR was, when did it fall down? 17/7/26.
Then that's
2 months yet to go.
Yes, that's what I'm saying. And secondly, page 36.
Where is
kindly-
that?
Page
36?
36, kindly see construction phase
Huh.
E,
Yes.
EC, the trial run for a period minimum 2 months.
Trial run for a period of 2 months.
Well, it was a complete, my lord. Once 99/2003 is completed, then the trial run will start.
Okay, anyway, I mean, you will not run away. This is
Yes.
AB.
How I will run away?
Yes.
There is no
So let
question.
it be, let him
I'm a
be.
contractor.
Okay,
I
yes.
can't run away like this.
Yes, entire project is almost over. Few months left.
Maintenance is my term. 5 years I have to maintain.
5 years from 2026 or 5 years from 23?
No, this will be 26 because there is an extension. See, please see.
5 years after 26?
Yes.
Okay. Heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. S. Das, Learned Counsel for the petitioner, and Mr. B. Sharma, Learned APP for the state. By this application, the petitioner has prayed for bail in connection with Dhekiajuli Police Station case number 199 of 2026, registered under section 290, 318 within bracket 3, 316 within bracket 2, and 24 within bracket 5 of the BNS 2023. The instant case relates to an FIR lodged on
17/7.
17/7/2026,
Yeah.
by which it was revealed that a water supply project which was initiated for water supply project which was initiated was initiated by a tender process and the work under the same was continuing. An elevated service reservoir fell down where fell down and that it was alleged that falling of the said reservoir within few months of partial commissioning of the said project raised serious concern as to the quality of the work. It is a full stop. It is alleged in the said FIR that although no substantial damage has been caused by falling of the reservoir thereof, but it had brought serious embarrassment for the mission in question as well as to the government of Assam. And as such, an allegation was made against the to the contractor that is the petitioner, for not doing the work properly. Full stop. The learned senior counsel for the petitioner submits that the said contract work for installing the Dhekiajuli town water supply project as well as for maintenance of the said project, a tender was floated. And in pursuance to the same, the work order was given to the petitioner and his company. He submits that the work order was floated, but the work was allotted to the petitioner on 20th of March 2023. And 5-year term was given to the petitioner, that is the contractor, for finishing the project, including 5 years of maintenance. Full stop. He further submits that the said work order was the completion of the said work order was extended by another period of 2023, 24, 20, 24, 25, 26, 27. No, 5 years have not gone. What is the extension?
No, they have to mean 9 September 2026, 9/9. First, by law, they have the completion of the project. Thereafter, 2 years, thereafter OM will start for 5 years.
5 years, okay. He submits that the completion of the project that is construction of Dhekiajuli water supply, including 5 years of operation and management,
Including.
was further extended till 9/9/2026. And he, by further placing the terms and conditions, have stated that 2 months period is taken for trial run,
Yes, minimum.
A minimum 2 months period is given for trial run. Full stop. He as such submits that there are 2 more months, more than 2 months is yet to go for completion of the said project, and the said 2 months is required for trial run. And as such, that reservoir, according to him, was not complete. And as such, the FIR is stated to be prematured, as it was not, as it could not have been used for ultimate public use before the completion thereof. Full stop. He accordingly submits that the allegation against the petitioner for not constructing the said reservoir properly is not meted out. On the other hand, Mr. B. Sharma, learned APP for the state, submits that falling of the reservoir after it was constructed at Dhekiajuli town by the petitioner and his company has to be taken seriously, and that the quality of the said project needs to be seen, and as such the FIR was lodged. On consideration of the submissions made for all the parties concerned, this court finds the following: the bid for the contract was floated in the year 2023, and it was stated. There's no government given, no? And it was for installing the water supply project in the town, in the Dhekiajuli town, and 5 years time was given under the said contract work for maintenance of the same. And there has been an extension of for completion of the project till 9/9/2026. As such, it is seen that the project has not been completed when the FIR was lodged. That is on 17/7, that is on 17/7/2026. And the project was directed to be completed by 9/9/2026. And there is a specific condition given that the after concluding the that after finishing the contract work, minimum of 2 months trial period should be observed. This trial period is provided for proper functioning of the said project. The trial period is yet to run. And as such, any fault with the project cannot be ascribed before the completion of the said trial period. In view of the same, this court finds it fit that the petitioner be released on pre-arrest bail on furnishing of a bail bond of rupees 30,000 with one local surety of the like amount to the satisfaction of the investigating authority under the following conditions. He will appear before the investigating officer as and when called for. He will not hamper with the evidence. He will not influence the witnesses. Petition is disposed of.
This will be marked as X, this letter,
Okay.
provisional. will be marked as X.
The extension letter placed by the counsel for the petitioner is marked, is kept as in the records of the
Yeah.
case.
Review of this.
No, if disposed of. Oh, God, what was it? Okay. I'll come back in 5 minutes.
The main accused person, the lordship, the two person, the Deepen Borman and the Ramesh Rabha lordship. And the lordship,
Acha, one second. I'm just going through it. Wait 1 second. So, no one is mentioned in the FIR as
Yes,
accused person.
Yes.
Okay, that
Yes.
that committee,
Yes,
Junjoli, what?
Yes, sir, but wrong.
Wrongly.
Wrongly?
Wrongly Boisago committee. And the lordship,
Yes.
the main accused person, lordship, prefer the bail.
And
application to be
you are the committee member?
Yes, lordship.
Wrongly
Committee
Boisango
member.
committee.
Yes. But lordship, the present accused person they collected the amount in the name of the committee. And the lordship, the main accused person, they preferred in the bail application before the court, and then now they are on the interim bail lordship. I want to submit the order.
But then see, you are like cheating the public, those.
So lordship, the entire allegation against the Deepen Borman and the Ramesh Sabha, because lordship, they collected the amount from the public.
Ramesh Rabha and,
Deepen Borman.
The Borman lordship.
yes, application to cause appearance of Deepen Borman and Ramesh Rabha.
Yes, lordship.
But you are also a member of the committee.
Yes.
Lordship, I am member of the committee, and the lordship, when the last pair of the affair lordship, it was mentioned that the lordship উল্লেখ কৰিব পাৰিলে উপহাৰ কোনো নামত সমিতি নকল ধন লৈ কেইজনমান বিলাসী বাহন প্ৰদৰ্শন কৰা হয়। এই সকলোবোৰ বাহন অন্য কোনোবা মালিকাধীন বাহন য'ত তেওঁলোকে সেই মালিক কেইজনৰ লগত নিৰ্দিষ্ট সময়ৰ বাবে চুক্তি স্বাক্ষৰভাৱে ৰাইজক প্ৰলোভিত কৰিছিল। প্ৰকাশ থাকে যে উক্ত দুজন ব্যক্তি যোৱা 1/2/2026 তাৰিখে ৰবিবাৰে অনুষ্ঠিত হোৱা ৰংজুলি বৈশাগু সমিতিৰ সাধাৰণ সভাত উপস্থিতিৰে স্বাক্ষৰেৰে আমাৰ সমিতিক আস্থা কৰিছিল। Actually, they admitted that they collected the amount from the public, lordship. Thereafter, the lordship, this affair was lost. And the lordship, the main accused person is the Dipen Burman. And the Ramesh Raha. Because lordship, they collected the amount in the name of our committee. So lordship, the affair was lost against them. And the lordship, there is no allegation against us. Because lordship, they collected the amount in our committee name. So lordship, that affair was the loss. And the lordship, the entire allegation against them, not us. But lordship, after lodging this affair, since we are a member of the committee, so police personnel searching us. So lordship, and lordship, the main accused person they are on the interim bail. So lordship, my
Okay, let them be also on interim bail. We'll call for the case diary, right? Heard Mr.
Yes, they will lordship.
S. Deuri, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail, prayed for pre-arrest bail in connection with Dhoop Dhora PS case number 32 of 2026, registered under section 61 within bracket 2 slash 318 within bracket 4 slash 316 within bracket 2 slash 336 within bracket 3 and 3 within bracket 5 of BNS 2023. The allegation against the petitioner. No. The allegation set out in the FIR dated 26/2026 is that the organizers of the Bikali Rongjali, Rongjali, Rangjali Boisangu, BOISANGU Samiti had organized a lottery and had taken money from the public and had also displayed few vehicles as prize money in the said lottery. However, it is stated in the said FIR that a forged permission was obtained from the administration to conduct the said lottery, and the vehicles which were displayed as prize money were also owned by respective owners, and that they are not new vehicles. The learned counsel for the petitioner, however, submits that petitioner is not involved in the said offense, and that these are also organizers, Dipen and Ramesh.
Yes, Lord.
Two members of the committee who are also organizers, namely Dipen Borman and Ramesh Rabha, were in fact involved in the said lottery. The petitioner is simply a member of the committee.
Yes, Lord.
Is simply a member of the committee who has no knowledge about organizing the entire lottery. He further submits that the main accused persons arrayed as such in the said FIR were granted bail by this court by order dated 26/6/2026. And as such, he prays that the present petitioner may also be granted interim bail. Mr. D.P. Goswami, learned APP for the state, however, submits that by holding that, holding that lottery, the petitioner, along with others, have cheated the public. Full stop. The allegation against the petitioner and others were that they had arranged a fake lottery only to amass money from the public. Para. On consideration of the submissions made by the parties and on perusal of the FIR, where the name of the petitioner does not find place, this court deems it fit that petitioner be released on interim pre-arrest bail on furnishing of a bail bond of rupees 20,000 to, here it is 30,000, 30,000. Bail bond of rupees 30,000 with a suitable surety of the like amount to the satisfaction of the arresting authority under the following conditions. Okay. Call for the case under the following conditions. Ekita condition did same conditions, huh? Etu lolo. And call for the case diary, list this matter on
18th August.
27th of August, it is fixed. 27th of July, it is fixed.
Yes, Lordship.
27 is gone. Today is 27.
Today. But Lordship city not read.
Acha. List this matter on 10th of August, 2026.
Yes.
Oh, but they take a date beyond that. 17th of August, 2026. Kika, call for the case diary. Okay. Case diary on 17th of August.
So item number 13 is a similar matter, Lordship.
Same one, the one you had given.
Yes, Lordship. Item number 13. Lordship, he is a teacher.
Oh, not this lottery.
Yes, Lordship.
Yes, Lordship.
Same matter,
Same,
Lordship.
same FIR.
Provindra Brahma.
Yes.
His name is
Provindra
also not there in the FIR. His name is also not there. Okay. Same hobo. Heard so and so by this application, petitioner has prayed for same case.
Yes,
Same
Lordship,
case.
Same case.
Name will be different.
Name is different only. Same order hobo. On interim bail.
Problem.
17-8.
17-8. তবু মোক দুইটা অৰ্ডাৰ বেলেগ বেলেগকে টাইপ কৰি দি দিবচোন মই চাম যদি কিবা আছে আইটেম 14. Yes, 14. Yes, Mr. Ali.
My lord, anticipated bail application. Lord, find the FIR page 7.
FIR. This is cheating.
Sitting,
This
my
is
lord,
cheating and
it has
all
been
those.
alleged that, my lord, in the year 2022, they have executed sale deed in favor of the, my lord, informant, 22. My lord, FIR laws and 16/6/26, alleging that the petitioner named in the FIR, there are 5 accused named in the FIR, my lord. I am Jahanuddin, my lord. They have, the informant said that they are the brokers. They are the brokers, they have seated, even after the execution of sale deed, they are not handing over the possession, my lord. So, my lord, CD may be called for, my lord, and my lord, I may be allowed to go on interim, my lord. If anything find against me, my lordship will my lord, reject the
Jahanuddin.
Jahanuddin, my lord. They
Wait,
have
I'll
no
just go through the
specific government, my lord.
FIR.
Only.
There is no specific allegation that Jahanuddin also have taken some money.
I'll just go to the FIR once again.
Lordship will
I
be
beg to state
seven.
Abdul Kalam, Jahanuddin. Residents of Inman, all the residents of Matia.
Vernacular test.
Okay, jointly propose to sell me part of land. Where is the owner?
That is not mentioned, my lord. As per instruction of my client, my lord, the owner is a person who belongs to Hindu community. And there is a problem, my lord, inter-religious transfer of land, my lord. The new notification has come.
Acha.
That might be the problem in handing over the possession and registration of sale deed, my lord.
But after prayer of the case diary and finding some incriminating materials against the petitioner, the trial court rejected the prayer of the bail petition. So after prayer of the case diary.
Call for the case
The case
diary,
diary.
but then let's see if he is entitled for any interim.
My lord, see that 2022, my lord,
I'm reading, wait. I have not finished reading.
lord, I'm sorry.
Okay, heard Mr.
M. Ali.
M. Ali, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with a Matia PS case number 63 of 2026, registered under section 120B /420/406/506 of the IPC. The FIR dated 16/6/2026 reveals that the petitioner, along with three others, four others, jointly promised to sell a plot of land measuring 25 litres covered by DAG number 425, Pata number 128. Full stop. It is further stated that the informant, believing their representations, believing the petitioners and others, believing the petitioner and others, executed a sale deed on 7/5/2022 and 19/12/2022, and in pursuance of the same, a total consideration of 2,70,000 was paid in 5 installments. However, it is stated in the FIR that although money was taken by the petitioner and others, but land was not given to him, and that later the petitioner and others had refused to hand over the possession of the land and threatened the informant not to press the matter any further. Learned counsel for the petitioner submits that he is not the owner of the land and that false allegation is made against him. What are your submissions?
Yes, ma'am.
False. And anyway, this person, the informant, without knowing the owner and all, he will give money to other persons. Right. So let him be on interim bail, Mr. Goswami. No case diary. Okay. Okay. Learned counsel kolo. Then the learned, however, Mr. D.P. Goswami, learned APP for the state, submits that the ingredients of cheating is writ large, WRIT, writ large in the FIR, inasmuch as the money was taken from the informant and possession of the land was not given to him. I've heard the counsels and I've gone through the records. It is noticed that in the FIR, it is not stated that petitioner and the others, that the petitioner is the owner of the said plot of land and sale deed was executed with him by the informant for purchase of the said land. Full stop. The informant had nowhere stated in the said FIR as to who is the owner of the land. And without knowing the owner of the land, no prudent person will enter into an agreement for sale and purchase of the land thereof. As such, this court finds it fit that the petitioner be released on bail, pre-arrest bail, released on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority under the following conditions. Petitioner to appear before the investigating officer as and when called for. Petitioner to refrain from influencing the witnesses connected in the case. The petitioner is directed not to tamper with the evidence of the instant case. Petition is disposed of.
Dispose of.
Yes. Yes,
May I please, Your Lordship?
yes, Bora.
My lord, the issue involved in the FIR is basically a civil dispute, my lord. The petitioner, my lord, entered into an agreement for sale with the informant, my lord. subsequently the informant came in touch with some another land broker who offered some more money. That's why, my lord, she has filed the FIR, my lord. That FIR, your lordship will find at page 20, my lord.
Did he take money from him, from the owner?
Yes, my lord.
Petitioner took the money.
Petitioner paid money as advance.
Or petitioner wants to buy that land?
Yes, my lord.
Acha,
And
then?
for that purpose, he executed one agreement for sale also. And now the informant, my lord, who is the owner of the land, in the meantime, she came in touch with some another land broker who offered some more money.
More money.
And that's why she wanted to sell the land to that land broker. The petitioner filed the objection before the concerned circle officer also, my lord. And when nothing was done, my lord, he has filed an title suit, my lord. In the title suit, my lord, praying for specific performance of the contract, my lord. In the title suit, the summon has been issued. After receiving the summon and notice, my lord, when the petitioner could not sell that particular land to the land broker because she did not obtain the sale permission.
The owner could not sell.
Yes. Then she filed the FIR, my lord.
Against the petitioner.
Yes, my lord.
Where is the
And
petition? Where is the
page
FIR?
20. And the allegation of forgery also there is not there in the FIR, my lord. Because signature and other everything is done by
Oh, that was a normal transaction,
Yes,
but
my lord.
then she
Yes, my lord.
got
it has-
attracted by more money.
Yes,
Where is
yes.
that? 20?
Yes, page 20, my lord.
This is admission or what? This is bail or what?
Yes, my lord.
Bail.
Page-
This is given item number?
Item 52 for motion.
Oh,
first time,
acha, 52 for motion, okay. So half of the amount she paid, 10 lakhs.
10 lakh.
20 lakhs was the total amount.
No, my lord.
60 lakhs per
60 lakh.
vigha.
No, my lord. Actually,
Ah.
that land is a separate one.
Ah.
That land stated in paragraph 3 and 4 is a separate one.
This is little clumsy, the FIR.
Yes, my lord. And regarding the page 3, paragraph 3 and 4, that has been, my lord, there was a registered agreement for sale. That
Acha, no, I'm seeing the FIR. She said that I requested petitioner to buy a plot of land measuring 2 bighas, 1 katha and 12 lechers. Dag number 56.
Yes.
He agreed to buy the plot of land in the rate of 60 lakhs per vigha. That means it will come to 120 lakhs.
Yes, madam.
1 crore 20 lakhs. That's sir, according to paid. He paid and accordingly, he paid rupees 10 lakhs. She is admitting 10 lakh as advance money. He got my signature and I received a set. She had admitted she received 10 lakhs.
Yeah.
There was no mention of any kind of land or region for receiving money. That sir, the said paper was prepared by him. That is the sale deed.
My lord,
But while putting my signature, I got a videography. Said, sir, in the paper, there was a gap between the signature and the last line of the paper. Later on, in the said gap, by forging the document to cheat me fraudulently to occupy my land, which I did not sold to him, mentioned the dark number and patta number of the land by any other computer and claimed the said land. This land, which he was claimed to have purchased from me, is 5 times more valuable than the one I actually sold to him. One plot of land she sold to him and she admits.
My lord, actually the FIR is a little bit clumsy one. Let me clarify, my lord. If your lordship comes to page 32, my lord, it is one agreement for sale that has been registered, duly registered. It is in respect of the land stated in paragraph 3, 2 bighas, 1 kotha, 12 acres.
Page
Page
32.
32.
Acha.
32, the
Mm.
original one. And that schedule of the land, your lordship will find at page 35. 2 bigha, 1 kotha by 12 acres.
Wait 1 second. 2 bigha, 1 katha, this one, 12 lesa.
Yes, my lord.
Huh.
But what the informant is trying to allege in the FIR, that is not in respect of this plot of land, because it
Acha.
is a registered agreement for sale.
Mm.
Then another registered, another agreement for sale, your lordship.
This land she had sold to the petitioner.
No, it has not been sold yet, my lord. For that also, now petitioner has filed another title suit for specific performance. of
Oh,
this contract.
okay.
Two title
But
suit
for this land, he has given 10 lakhs as advance.
to 20 lakhs.
20 lakhs?
20 lakhs.
Okay.
10 lakhs in respect of the second one, my lord.
Oh, okay. Acha.
So in the FIR, it is not clear.
Hmm.
But if your lordship comes to page 37, annexure 4,
Hmm.
it is the translated copy, and the original copy your lordship will find at page 39 and 40, my lord.
Hmm.
40, the
It's
original-
okay. Let me English is wrong. No, no.
Yes.
Translated copy is okay, right?
Yes,
Uh-huh.
okay. Translated copy is also right, my lord.
So the deed of money agreement.
Yes, my lord. So in this particular plot of land, my lord, covered by Dag number 49, Pata number 135.
Huh.
Area 1 bigha, 4 kotha,
8%.
8 lesa. In respect of this plot of land, she has received 10 lakhs rupees.
Okay.
So now, if your lordship sees the vernacular, what she is trying to allege is that page 40, my lord, she is trying to allege that, my lord, the entire agreement was executed, she has put her signature, but the land description has been put in this agreement later on. That is her.
Acha. Matir Poriman.
Yes, my lord. That
Baina Kitra Party, this statement was later on inserted.
he alleged, my lord. But otherwise, my lord, and regarding that, my lord, in respect, and regarding that, my lord, I have already filed a title suit, my lord.
So title suit was filed in respect of both the lands.
Both the lands, my lord. And a summon has been issued after receiving summon, my lord, she has filed the FIR. my lord. So basically, otherwise it is a civil dispute. Basically, there is no ingredient of any criminality on the part of the petitioner, my lord. Because the allegation regarding the page 40, my lord, only this particular allegation that the land description has been put in that agreement later on.
Okay, let me dictate.
That is also not
Yes.
sustainable. How they
Heard Mr. D.P. Bora, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Doboka PS case number 99 of 2026, registered under section 316/336, within bracket 3 of BNS 2023, full stop. The FIR dated 8th of July 2026, filed by the informant, reveals that the informant, being one of the daughter, that the informant had inherited part of the land left by her father, and that she entered in an agreement with the petitioner for sale of a plot of land measuring 2 bighas, 1 katha and 12 acres, covered by Dag number 56 and Patta number 161. Full stop. She further submits in the said FIR that 10 lakh was paid as an advance money by the petitioner. But the property which she intends to sell to the petitioner was a much more valuable than the one which she had sold to him. It is somewhat she is written like that.
Yes,
sold to him. She states in the said FIR that she had agreed to sell the plot of land which is covered by 2 bighas, 1 katha, 12 acres, as mentioned above, at a rate of 60 lakhs per bigha. Full stop. She submits that in the sale deed, there was a gap between her signature,
Agreement for sale.
in her agreement for sale, not sale deed, huh? That in the agreement for sale, wherein she had put her signature, there was a gap between her signature and the last line of the said agreement. Full stop. She further alleges that in that particular gap, another plot of land was reflected and which, which was of a lesser value. Full stop. She as such alleges that the petitioner had cheated her in respect of sale of her property. The learned counsel for the petitioner, however, submits that there were two plots of land which were intended to be, which the informant wanted to sell to the buyers. And in respect of one plot of land, which is covered by one plot of land, which is 1 bigha, 4 katha and 8 lechas. Where is the dark number here? There are two dark numbers, two patta number what?
Yes, my lord. Two plots of land, my lord.
Acha, page number 40 is one plot where it is said that he had inserted.
Yes,
And this one, she had not sold to him, according to her.
yes,
Right.
yes.
She submits that, what did I say? In last line. She submits that there is insertion of one line giving the description of the land, and in which she had received 10 lakhs of rupees at advance. And according to her, that plot of land she has not sold to the petitioner. The learned counsel, full stop. The learned counsel further submits that there is another plot of land Where is that another plot of land, Mr. Bora?
My lord, that,
If that plot of land also she desires to sell it to the petitioner.
yes, my lord.
She entered into a agreement.
Yes, that has been registered also, page 32, my lord.
In respect of the other, in respect of the other plot of land also, in respect of the other plot of land also, he submits that in respect of the other plot of land also, the informant has entered into an agreement for sale with the petitioner, for which the informant has also received money from him.
20 lakhs.
That is to the tune of rupees 20 lakhs. The learned counsel further submits the title suits have been filed for specific performance of the contract agreement
Yes, good.
by the petitioner in respect of both the lands.
Title suit also I have.
Full stop. He further submits that the informant, after receiving the summons in one of the title suit, had filed the instant in both the title suit, has filed the instant FIR against the petitioner. Learned counsel for the para. On the other hand, learned counsel for the state submits that it is revealed that the petitioner had in fact taken money from the informant. Oh no, petitioner had in fact given money to the informant.
And she has also not denied that she has not received.
Yes, she had said.
Yes.
And that the informant has also accepted that she has accepted money from the petitioner. But it has been specifically stated in the FIR that forgery has been done by the petitioner in respect of the lands in question. Para. On the consideration of the submissions made by the learned counsels for the parties, it is seen that the petitioner had filed two title suits, being title suit number 44 of 2026, as well as title suit number 38 of 2026, for specific performance of the sale agreement between the petitioner and the informant for both the plots of land. And the said cases are pending disposal before the learned courts. As such, it is seen that the instant case is of civil nature, and the entire gamut of the case is looked into by the trial court. In view of the same, no, not in view. Further, it is also noticed that in the FIR, the informant has accepted that she has agreed for sale of her land to the petitioner, as well as has received money from him. As such, this court finds it fit to release the petitioner release the petitioner on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the investigating officer.
Interim may be granted to him and CD may be qualified.
Mhm.
Interim may be granted to him and CD may be qualified. I mean,
Not require title suits are there. It will only like increasing the court's work. Okay, petition is disposed of. Hey, kita condition dito na. Yes.
Deeply operated.
Criminal revision, or I'll take up the bail matters first. Okay, there are only two. Okay. What is this revision about?
This is arising out of an NI closure. Although the PCR is available, the petitioner does not wish to press the matter on merits. However, the petitioner is willing to explore the possibility of settlement through mediation.
Okay,
My-
so let it go for mediation then. Right, agreed?
Lordship, we are agreed to, always ready to dispose of this.
No,
Only
try it
issue
out
that-
there.
Yes.
If
as
it
to
fails,
see-
come here.
That may be fixed for mediation losses so
Okay.
that we can.
Heard, Miss
P. Bora.
P. Bora, learned counsel for the petitioner, also Mr. J. Kolita, learned counsel for respondent number 1, and Mr. D.P. No, state is not there, right? Okay, respondent, sole respondent.
Sole respondent.
Sole respondent, huh? J. Kolita for sole respondent. The learned counsel for the petitioner submits that the matter be sent for mediation amongst the parties to the Gauhati High Court Mediation Center. The sets full stop. The said submission is agreed to by the learned counsel appearing for the sole respondent. As such, matter is sent for mediation to the Gauhati High Court Mediation Center. The coordinator will appoint
Necessary, what I hear, Lordship, we can settle the issue.
no,
If-
appointing a mediator. The full stop. The Gauhati High Court Mediation Center will appoint a mediator, and the said mediator would take up this case on. You want a date?
Actually, fix a date.
Or mediator will fix a date. Don't worry. At the earliest.
Yeah, but it may take time, so Lordship.
At the earliest.
Lot.
At the earliest. Prepare, and after conclusion of the mediation, prepare a report and send it to this court. List this matter after 1 month on a date to be fixed by the registry. On receipt, list this matter after the report from the mediator is received. List this matter after the report from the mediator is received.
Pledge, Lordship.
Case diary is called for? This is quashing of FIR. Huh? Quashing of FIR.
FSL report also was called for. FSL and CD was called.
Let's see, what is the FIR? Why do you want quashing? Show me. Case diary is here, right, Mr. Bankim Sharma?
yes, madam.
Show me the FIR. FIR is at page 9. Page 9, right?
Yes, yeah.
Okay, I'll read it myself. Wait. I read this story before, maybe in bail jurisdiction or something. The money, the vehicle carrying money is intention to loot an amount of 12 crores.
Another aspect is there, my lord.
Wait 1 second, I'll just finish reading.
Yeah, ma'am.
Not an FIR for washing.
Oh, yes.
See, this case I read it before in somewhere. So they had the information that some vehicle was coming. They had the information that there is transportation of fake currency notes as well as black money. And this vehicle was coming from Bongaigaon. Oh no, from Gauhati to Bongaigaon. It was going there.
Yes.
So as per information, there was a Naka checking. They intercepted a vehicle which was actually going from Gwalpara towards Bongaigaon side. They were waiting where? Naka checking near Narayanan Setu.
Yes, my lord.
The vehicle was actually going from Guwahati to Bongaigaon.
Yes, my lord.
Right. During Naka checking, one vehicle so and so were intercepted was proceeding towards Gwalpara, from Gwalpara towards Bongaigaon.
Yes.
From Guwahati towards Bongaigaon and from Gwalpara towards
No, my
Bongaigaon.
lord.
Route is different. Or?
Perhaps it is from Tura.
No. Tura that is another vehicle.
Yes.
See, this is another vehicle.
Yes.
On seeing the Naka checking, the team immediately turned back the vehicle towards Gwalpara. The team immediately turned, seeing the Naka checking, so the vehicle returned from there, right? And they started going towards Gwalpara.
Yes.
And complainant along with his staff chased it, and with the help of Gwalpara police, they intercepted, arrested.
Yes.
They could not give their identity.
Yes.
Then, on interrogation of the apprehended persons, it is found that they were coordinating with one Bhaskar Boro, on mobile phone with intention to loot an amount of 12 crores, which is coming from Tura, Meghalaya towards Bongaigaon side.
Yes.
I think there are two vehicles.
Yes.
They were coordinating with one Bhaskar Bora on mobile phone with intention to loot an amount of rupees 12 crore, which is coming from Tura, Meghalaya. Intercepted before committing the crime. They were about to loot
Yes.
12 crores, which is coming from Tura, Meghalaya. So before they could do it, they were arrested. And they had shown their identity as some big officials.
Big officials.
So this is a case not to be interfered with. Let the investigation continue. I think you are on bail.
Bail or assault? Yes, they are on bail.
This is not a case for
And
caution. Without seeing the case diary. See, 310 for 319 61. These are all attracted, the facts of the case.
Yes.
Let the investigation go on. I'll dismiss this matter.
Yes.
Quashing it is not possible.
My lord, another aspect, my lord, they use some, my lord, identity cards.
Oh, yes.
But that identity cards also found, my lord,
Fake.
hack.
They were of big intelligence officers.
Yes.
This petitioner is
From the respective authority, my lord, the clarification is in the case.
So this is moved by only one, I think. This application is moved by one of the petitioner.
One of the.
Wangkhem, the accused number 1.
Yes.
Wangkhem Milan. And Wangkhem Milan had shown the ID card in the name of National Intelligence Bureau and identified himself as a senior officer.
Yes.
Okay. Heard Miss?
Yeah.
Heard Miss A? Afreen, learned counsel for the petitioner, and Mr. Bankim Sharma, learned APP for the state, by this application filed under Section 528 of BNSS 2023, read with Article 227 of the Constitution of India. The petitioner has prayed for quashing of the FIR registered before the Jugigupa Police Station and numbered as Jugigupa Police Station case number 91 of 2025. the FIR dated 1/8/20 para, 1/8/2025 reveals that on an information received from a reliable source, the police personnel from Jogigopa police station এটা কাম কৰক। On an information received from a reliable source that দিয়া পুলিচটো বাদ দিয়া that a racket who involves themselves in transportation of fake money, fake currency, as well as who involves themselves in looting black money from businessmen were coming by a vehicle from Bongaigaon or from Gauhati towards Bongaigaon, comma, the police personnel from the Jogigupa police station conducted a Naka checking, and during the same, at around 2:20 p.m. on 31/7/2025, they saw a vehicle bearing registration number AS01 FY 4447 was proceeding from Goalpara towards Bongaigaon. And on seeing the Naka checking, the team inside the said vehicle turned back towards Goalpara side. Full stop. The police team chased the said vehicle and with the help of Goalpara police intercepted the said vehicle and arrested 4 accused persons from inside the vehicle. Full stop. The police personnel asked the said accused persons their identities, but they could not give proper answers. Full stop. Thereafter, it is further stated that on interrogation of the said accused persons, it was found that they were coordinating with one Bhaskar Bora. Bhaskar Boro, with the intention to loot an amount of rupees 12 crores, which was brought in a vehicle from Meghalaya towards Bongaigaon side. Full stop. It is stated in the said FIR that before the accused persons caught in the other vehicle could loot the money from the vehicle which was coming from Meghalaya, the said vehicle was intercepted and the persons were arrested. Full stop. The informant further stated that allegations not only rested at that, but also that while asking for the ID proofs from the said accused persons, the accused persons had given fake identity proofs to the police personnel. And it is specifically written in the said FIR that the petitioner, namely Wanghem, WANGHEM, Milan, MILAN, Singh, SINGH, produced an ID card in the name of National Intelligence Bureau, within bracket NIB, and he identified himself as senior officer of the said organization. Full stop. The police personnel on on inquiring about the said ID proof, found that the same was fake. Full stop. In the said FIR, 4 numbers of accused persons were arraigned as accused of the said offense, and petitioner was mentioned as accused number 1. It is this FIR that the that the petitioner has prayed for quashing of the same. Learned counsel for the petitioner submits that the story projected in the said FIR is not correct, and that the petitioner is not involved in the said offense. Learned counsel for the respondent, that is the state of Assam, Mr. B. Sharma, however, submits that not only the petitioner along with others were apprehended by the police when they tried to run away after seeing the Naka checking, but also the identity proofs placed by the petitioner was fake. Where I have considered the submissions of the parties and have gone through the copy of the FIR as well as other papers on record. It is full stop. It is noticed that when the petitioner along with others saw the police personnel standing at a particular point, to disrupt, to catch illegal activities, the petitioner along with others had changed the course of the vehicle and tried to flee away. Full stop. The petitioners or the police personnel of Jogikopa police station had in fact chased the said vehicle and intercepted it after some distance and apprehended the petitioners and the others, petitioner and the others. And on interrogation of the petitioners, they found out that they, in connivance with another person, had decided to loot money which was coming from Meghalaya towards Bongaigaon. And the ID card that were placed by the accused persons were also found to be fake. In view of the said circumstances, this court does not deem it fit to quash the FIR of the instant case, being Jogikopa police station case number 91 of 2025. As such, this case is dismissed. Oh, it's past 1. Okay. How many matters? Now there are bail hearings. How many case diaries are there? Number of them? Okay. We can finish it in the second half. Yes, which item?
Yeah, Lordship, this is a trial is going on in this case, Lordship. On the last occasion, Lordship, the 180 statement of the victim was called for. That has not been received as per the office note dated 16/7.
Date may be given, fixed.
Hmm?
A date may be fixed, Lord,
Yes.
until the arrival of 183 statement. Lord.
Means the case diary has come, but the victim statement is not there.
No, it's a charge sheeted matter, Lordship. The records are before your Lordship. But the CD part where the 183 is there, that is not before your Lordship. Well, ultimately, Lordship, this case will proceed because this is a gang rape case, Lordship. And the case is fixed for evidence. So none of the witnesses have been examined so far, Lordship.
Acha.
So that is why probably the 183 statement was.
So the case diary has come or not, along with the records?
Case diary not there, Lordship.
Case diary was not there.
CD part is not available, Lordship.
Not available.
Lordship, there is the last order that will be.
What has come? Only the statements, only the orders, orders.
Then the charge sheet.
Okay.
Office notice there, Lordship,
Office
16/7.
Scanned copy of the entire case diary
Yes.
has not been received.
Yes.
Okay. You are on interim?
No,
No.
no.
Heard, Mr.
D may deal.
This is what item number?
19.
19. Heard Mr. D. Medhi, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. Although on the last occasion, the scanned copy of the case diary, including the statement of the victim recorded under section 183 of the BNSS was called for, but the office note dated 16/7/26 reflects that the said statements are not there in full stop. In fact, the case diary has not come. As such, the registry is directed to send reminder for receipt of the case diary, for receipt of the case diary that will be available with the trial court.
Yes.
Okay, may list this matter for further consideration on 10th of August, or wait, on
Little bit
6th of August,
6th of August.
6th of August 2026.
Obliged.
20, Lordship, charge sheet has been submitted.
Acha. You will move it there?
Yes.
59 days, Lordship.
No, it was submitted way back, Lordship. On 28, it was submitted.
So today is the 59th day.
59 days.
60 days is the period.
It was
Oh,
submitted
acha.
on-
Case diary was it was submitted long back, it is
Yes.
said. So the charge sheet is submitted, so you move it there? Heard, Mr.
Islam, Lordship.
B. Islam, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. Mr. B. Sharma submits that the charge sheet in the instant case has been laid by charge sheet number
33/26, dated 20/07/26.
As such, the learned counsel for the petitioner prays that he may be allowed to move the appropriate application before the appropriate court of law. Prayer is allowed. Prayer is allowed. Matter is closed. Matter is closed.
CD not received, Lordship.
Okay. Mr. B. Sharma, learned APP, submits before this court that the case diary, as has been called for, has not been received
And they were on interim, Lordship, if I'm not wrong.
and has prayed for a date to be fixed for bringing the case diary. Prayer is allowed. List this matter on 11th of August.
Lordship.
11th of August 2026. Interim order passed earlier shall continue until the next date of listing.
Lordship.
Same here also?
Same case, Lordship.
Okay, same case, huh?
27, Lordship, the FSL report was called for, Lordship. That has not been received.
Okay. The councils are not there. Case diary along with FSL not received. Earlier also it was
Case
not.
diary has been received, Lordship.
Acha, acha. Okay. None appears on call for the petitioner. Mr. B. Sharma, learned APP, however, submits that as has been ordered on the last occasion, case diary is received, but the FSL report has not been received till date. As such, it is directed that the learned government advocate would place the FSL report on the next date fixed. Fix this matter on 13th of August.
13. Lordship, we will be allowed to send back the CD for updation also, Lordship.
Okay, otherwise interim there, no.
No, interim is not there. In the case of murder, Lordship, the FSL report will be.
No, we'll fix a short date then. List it on 6th of August,
Lordship.
2026. Further, the learned APP is given the liberty to send back the case diary and get an updated one
Lordship.
on the next date fixed. Hmm. 29.
29.
Hmm. Case diary is returned.
Received.
Uh-huh.
29, Lordship, CD is received.
A CD is there.
Yes,
Earlier it was received and it was sent back.
now it has been received,
But
Lordship.
the council is not there.
Order is not there.
29, right?
Yes.
Mr. I. Alam. Okay, call it up after some time. We'll call it after some time.
Wait, please, Your Lordship.
Mm.
My lord will peruse the last order dated, my lord, 5/6/2026, my lord. for the moment.
What is the date of the last order?
5/6/2026, my lord.
Okay, yes.
I was granted an benefit of interim bail, my lord.
Mm.
And accordingly, I have appeared before the IO, my lord. And therefore, my lord, I'm otherwise, my lord, satisfying all the bail conditions, my lord. Bail maybe, my lord, may be made absolute, my lord.
Acha, your statement was recorded.
Yes, my lord, statement has been recorded,
Okay.
my lord.
Okay, heard Mr. ABD, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with,
PS case number, my lord.
in connection with,
Duarbon PS case number 21/2026, my lord.
Duarband.
Duarbon, D.
Duarband PS case number
20.
21 of 2026. Registered under section 109/127/351 within bracket 2/3 within bracket 5 of the BNS 2023. Where is the FIR?
My lord, FIR is in page number, my lord.
46.
46, what?
46.
47 is the translated.
46, A.
Yes.
The FIR dated date
Typed copy is at 46.
23/4/26. Where is the original copy?
My lord, 47. Starts at 47.
51.
51, my lord.
That is the vernacular one, Lordship.
No, I'm not getting the date.
Date, my lord, is
Date is there, Lordship.
20.
Date
12/4/12.
23/4/26.
It is registered on 23/4/2026. It was filed on 12/4/2026.
12/4.
Yes, my lord.
12/4/2026, wherein it was stated. It stated that by the informant that the brothers and sisters of her husband were creating disputes and quarrels regarding their joint property. And that on 11/4/2026 at around 2 p.m., the three accused persons named in the said FIR forcibly made her husband to sign blank papers and attempted to murder her husband by administering poison mixed in a cup of tea. Full stop. It was also stated that the husband of the informant was locked inside a room and that he shouted for help and the local people rescued him. She also, full stop. She also stated that her husband was admitted in the hospital and he was undergoing treatment. It is seen that the petitioner was enlarged on interim pre-arrest bail.
5/6/26.
Interim pre-arrest bail by order dated 5/6/2026. Petitioners, 2026. Full stop. The learned APP for the state submits that pursuant to the said. Oh, no, before that, was enlarged, or suing petitioners. With the condition that the petitioner should appear before the investigating officer within a period of 15 days from the date of the order. Full stop. The learned APP for the state submits that pursuant to the said order, the petitioners appeared before the investigating officer and their statements were recorded. As such, it is noticed that the petitioners are cooperating with the investigation of the case and this court thinks it fit to enlarge the petitioner, thinks it fit to
Make the absolute.
to make the order dated 5/6/2026 as absolute. Ordered accordingly, ordered accordingly, Liz, petition is disposed of.
My lord, will it be allowed? My lord?
Huh.
Disposed of.
It thinks it fit, or we want, add a sentence, thinks it fit to allow petitioners as such are, bail order of the petitioner as such is made absolute. Petition is disposed of. Yes, 29. Hmm. The case diary is here.
Yes, Lordship.
Were you on bail? No.
My lord.
You were on bail, interim?
No interim.
Acha. Show me the FIR.
Regarding my lord, parking of a vehicle, my lord.
What is this issue?
Issue regarding the parking of the vehicle, my lord.
Parking of vehicle.
Yes, ma'am.
Okay, show me the FIR.
Page 12, my lord.
12.
Updated copy, my lord. The informant went to his sister's flat.
Wait, to the officer in charge, accused, there are so many, 7 of them.
No, my lord, out of them, my lord, accused number 1 already granted, he is a minor already granted bail. And accused number 4, Hafsa Begum, she is also granted bail by the Lanark Session Judge. Accused number 7, my lord, also granted bail.
So 3 are not there.
No, my lord.
So rest, 1, 2, 3, 4.
4, my lord, I have
How many petitioners are before me? 4.
4, my lord.
4. Rest of the 4.
My
Islamuddin, Muslek, Ansar, and Rapson.
Yes.
Okay.
It's, actually, my lord, Muslahuddin, my lord, it's a epilepsy, my lord. I have also enclosed his medical report, my lord. He is suffering epilepsy, my lord.
Okay, let me read the FIR first. I'll read it myself.
Page, my lord, starts from page 12, my lord.
Acha. Okay. So, where was this occurrence took place?
My lord. Occurrence to the in front of the house of the accused person, my lord.
Rajghat near Hawaii Thang roadside.
My lord.
Okay. Before reaching Mizoram. He was on his way to Mizoram.
My lord.
Then?
Then, my lord, he lost the FIR. In fact, my lord, he attacked the accused number 4, my lord, Hafsa Begum. I have also enclosed her medical report, and they have also lost an FIR, but that was not registered, my lord. Because he is an influential person, and then, my lord, he is also working at Mizoram, my lord. So
He is working as a professor in some Mizoram college, not such an influential person. So what happened after that? You were inside?
No, my lord, we are outside.
Anticipatory.
Oh, this is anticipatory. So, okay. Well,
And I have been on record the medical report of petitioner number 1 and 2, my lord. Both of them are brothers, my lord.
what about injury on the petitioner, on the victim?
Lordship, I have given the medical report.
This one?
Yes. He has suffered a blow in his head, Lordship, which has been termed as grievous.
Right side of occipital region, right region, right shoulder, grievous, blunt, physical assault, fresh, out, written.
Admittedly, Lordship, there was a altercation. Lordship. So that part is only there. Whether Lordship custodial interrogation is
You should
required.
remove your vehicle. You have not removed your vehicle.
No, my lord,
And in turn, on the other hand, you have started assaulting. What is the other story otherwise?
in fact, my lord, he came before to ask my lord and asking my minor son, my lord, that is the accused number 1, my lord, to remove the vehicle.
Huh.
When he told him that he don't know about the vehicle, my lord, he slapped him. Informant slapped him.
The
and
vehicle
then-
was not theirs.
My lord, no, my lord.
Vehicle was
It
somebody
is
else's.
outside, in front of my house, my lord. The informant thought that the vehicle belongs to us. That's why quarrel took place. my lord.
But none of you own the vehicle.
No, my lord.
Okay. You'll be on bail.
Lordship.
Yeah, yes, you are for the
I am for the informant.
informant.
I am submitting my written objection, Lordship, because he is a scholar, Lordship, and there is another story behind it, Lordship.
Mm.
This is Page 45, Lordship, of my,
Of your affidavit.
because basically they anticipated he is a police person, and as per.
Oh, he's a
their
police
report,
person.
They are the drug peddlers. That's
No,
why
my-
they attack this person, Lordship.
This is the scene created by the informant, my lord. Why all of them have same village, my lord? Then how they don't know
Group of
about
people
he
attack.
is a
All these
person
seven
and
people,
this?
all these 7 persons are related.
No,
No.
my lord, they are not related, but from the
Same
village,
house, Lord. Same
Acha, what were
locality.
you showing?
same locality.
Yes, Lord. One is the medical report, your Lordship already find.
Page?
Medical report, I think my learned friend already submitted.
Yes, that I have seen.
Yes. And the photograph, your Lordship may find it page 41, Lordship.
Hmm.
Damaged vehicle, also I have an ex-Lordship, 42. How barbarically
By the
they attack.
villagers, my lord. In
on
fact,
this
he
person.
attacked the women, my lord.
Hmm.
Attacked the accused number 3, my lord. That's why local villagers have also come to their rescue, my lord.
Oh, this is another story. He attacked
Another
the
story, my
woman.
lord. Yes, my lord.
And that
And
is
they have also lodged a complaint case against him.
Hasfa Begum.
And I have also annexed the medical certificate, my lord. on-
And they were all known to each other.
All the accused, Lordship.
And with the victim?
No, no, no. Not known, Lord. Kindly have page 45, Lordship.
Huh.
Media reported that,
Hmm.
Lordship. দোলাই মাদক মাফিয়ার হামলায় গুরুতর যখন মিজোরাম বিশ্ববিদ্যালয়ের গবেষক এলাকায় চাঞ্চল্য লড়ছে। Even recently also the media also published this news because no one was arrested, Lordship. Even 3 months.
Acha, they
of
were
the-
all intoxicated.
my
Madok
God.
মাফিয়ার হামলায় ধলাই মাদক মাফিয়ার
Otherwise,
হামলায়।
why they tortured a innocent?
Acha, where is your FIR?
My lord, my FIR is not registered, my lord, but I have
But-
annexed this, my lord.
Let me see the copy content.
Yes, page 20, my lord.
Page
The medical
20.
report which has been, they have annexed, is pertaining to 2016, Lordship. The recent medical report
26, my lord.
for
no?
accused person they filed
23,
additional
Lord.
affidavit is
Hmm.
pertaining to 2016.
Let me
This is-
submit, my lord.
Acha, one
That
by
is
one, wait.
in page
26.
79. Page 20 is my FIR, my lord. It was not registered.
No, not 28, 29. No,
Page 20, my lord, in my bail application.
20. Acha.
20. Translated copy.
Allegations are also there that you had also, he was with the driver or he was alone in the vehicle or what?
He is alone in the vehicle, my
No,
lord,
no,
and
he
then
was
come
not alone.
some other persons, my lord, to with him, my lord. With the
No, no,
informant.
he is on the way
To
to
Mizoram.
participate in a marriage ceremony with his mother, Lordship,
The victim?
victim, Lordship.
Oh, that is not reflected. It is said that while he was on his way to his work.
No, no, Lordship, it's completely a concocted story, Lordship.
Huh.
Otherwise, why not police registered this case?
No, that is your FIR. You said I was returning to my works and on the way towards my destination. You did not say that any marriage and all. One vehicle was parked in front of the house of the accused person for which I could not move my vehicle.
No, 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 Lordship.
With the new stories, they have filed
See,
the
Lordship,
objection, my lord.
I
I
beg
have
to state
also,
that at present, I have been discharging my duties, Professor of Mizoram University. I came to my
That we are
house
not denying.
on the occasion of my cousin sister's wedding. When I was returning to my works and on the way towards
Wedding
the
was
destination
over.
of the
He was
vehicle,
going back.
I think prestation was wrongly given, Lord.
my lord, may I kindly peruse
Acha, okay,
the
show me the vernacular.
vernacular is page 18, my lord.
18.
18. In my bail application. Nivedon is in Mizoram Vishwavityalayar.
Acha, read it. It's in Bengali. I'm only able to.
Yes. I have the directive is not illegible.
My lord, I read it.
Yes.
বিনোদন নিবেদন এই যে মিজোরাম বিশ্ববিদ্যালয়ের অধ্যাপক পদে কর্মরত আছে আমার কৃষির মেয়ের বিবাহে উপলক্ষে বাড়ি আসিয়েছিলাম হয়তো ঘটনার সময় আমার কর্মস্থলে যাওয়ার সময়
কি আমার?
কর্মস্থলে যাওয়ার সময় দিস ইজ গোয়িং টু হিজ ওয়ার্ক প্লেস অপস্থলের ঘটনাস্থানে রাস্তার বিভাজনের প্রতিটা মানুষ
So while he was going back to his work only, not to the marriage. Marriage was over.
The marriage was over, Lord. And then he went to the Mizoram, Lord.
That is on his way to Mizoram. Yes.
And one thing, my lord, your lordship, I kindly peruse my additional affidavit, my lord. I have bring on record the Hafsa Begum, that is the accused, the medical report, my lord. Page 79, your lordship.
Page?
Page 79, my lord. In my additional affidavit,
Okay. Page 79.
my lord. That on 28,
Wait, wait.
2026.
79, yes.
79.
Huh. This is Hafsa Begum.
He told.
Physical
lordship
assault
that
on
is 16,
28.
But it's 28/3/2026.
Yes.
No, no, I am talking about the page 62, Lordship.
Acha,
And
one
then,
second.
my lord,
Let him finish, then you say. In between, he is doing what you're saying. Yes. Hafsa Begum,
Yes, my lord.
28-3.
Yeah, 28,
Physical
it
assault
pertains-
on 28-3.
And
Rajghat.
epilepsy report of the petitioner number 1 at page 60, my lord.
Some finger injury.
My lord.
Okay, she also got injured at around 3:20 p.m. or 2:30. 2:30. 1:30. Okay.
And
Yes,
his
what are you?
vehicle was damaged by the local people, my lord, not by us, my lord.
And vehicle, the photographs or the vehicle was of the victim.
Victim, Lord.
Important.
MBA report also is there.
His vehicle was damaged.
Damaged, my lord, that by the local people when she attacked the Hafsa Begum.
Lordship, it is not in record, but I have a video clip of this fight. It's short video clips where it's clearly is visible that Hafsa Begum how attacking through a lathi to the victim, Lordship. But it's not, I think it's not diary. If
Let
the
you
Lordship
place
wants to
it.
see, I can show.
Let
Place-
them
It's
appear, my lord.
available on.
My lord,
You
let
can
them
place it
appear.
during the trial.
Let them appear and that will be proved before the trial, at the time of
I am
trial. Let them
making
appear,
a
my lord.
custodial interrogation
Where is the
of-
power, my lord? After
My
4
lord,
months already.
Who
I am
is
praying
incidentally
for
it's
bail
3
of
months-
both.
This is AB,
Yeah,
right?
Lordship. Because already 3 months elapsed, police, no one arrested by the police.
Acha, what do you say, Mr. Sharma?
Can be disposed of, sir. There was an altercation. There is no doubt about it.
But
And
perhaps victim was alone in his vehicle or he had his driver or somebody.
that is not clear from the case diary also, Lordship. Otherwise, the report is before the Lordship. Only the thing is regarding custodial interrogation, if it is necessary or not. That I leave to your Lordship.
Let them appear before the police, my lord. I have.
They will
will provide
be
the-
directed to appear and give their statements.
My lord.
And if you do not, then we will cancel the bill.
My lord.
Heard, Mr. I Islam.
Alum, my lord.
I Alam, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state, and Mr.
THO.
T. A. Chaudhary, learned counsel for the informant. By this application, the petitioners, that is 4 in numbers, have prayed for bail in connection with Dholai PS case number 30 of 2026. Registered under section 191 within bracket 2 slash 191 within bracket 3 slash 118 within bracket 2 slash 3032 324-4 of BNS 2023. The FIR connected with the instant case reveals that the FIR connected with the instant case filed by the informant reveals that he was working as a professor of the Mizoram University and that he had come to his hometown on the occasion of a family wedding, and while he was returning for his work, he found a vehicle parked in front of the house of the accused person, because of which his vehicle could not move forward. Full stop. He further stated that unable to ply on the said road, he requested the accused persons to move their vehicle. But instead of the accused person removing the vehicle, attacked him with sticks and other sharp weapon. Full stop. He also states that during the scuffle, the accused persons stole his gold chain and snatched money from him. And that he was physically assaulted and he was injured and that he was admitted in the hospital. Where the learned counsel for the petitioner submits that the story projected in the said FIR was incorrect and that it was the petitioner who had asked the accused number 1, who was minor, to remove the vehicle. And when the minor replied that it was not his or his family's vehicle, the petitioner assaulted the minor as well as the mother of the said child. Full stop. He further submitted that during the scuffle, the local villagers came and the assault took place. The learned counsel further submitted that the mother of the minor, who is arraigned as accused number 4, who is arraigned as accused number 4 in the said FIR, was assaulted and she sustained injury in her finger and other parts. And to substantiate this contention, the learned counsel has placed the medical certificate issued to the mother. On the other hand, Mr. B. Sharma, learned APP for the state, has placed the injury report of the informant, that is the victim, and the said report shows that the victim sustained grievous injuries on his head. The learned counsel for the informant further submits that the victim was badly beaten up by the petitioners on his endeavor to get the vehicle removed from the road so that he can go ahead for his work. He can go ahead to the place of his work. On consideration of the submissions made by the parties, it is seen that there was a scuffle between the parties and in the FIR lodged by the petitioners, which was, although not registered, it was stated that in the victim's vehicle, there were more than one person and that victim and others had attacked the petitioners. It is also seen that one of the accused was also injured. And in the doctor's report, it is not stated that the said injury was self-inflicted. Or caused. No, and in the doctor's report, it is seen that the physical assault on the said accused person occurred on the same date at around 2:30 p.m. at the same place. In view of the same, this court finds it fit to release the petitioners on bail, on pre-arrest bail, on furnishing of a bail bond of rupees 20,000 each, with one local surety each of the like amount to the satisfaction of the arresting authority on the following conditions. Wahi sab. Petition is disposed of. Oh, you can, Amanda, I think. Yes. 31. Yes. Case diary is there, Ms. Bora?
Scan copy of case diary has
Achha.
called for, that is.
Have you seen?
Yes.
Yes.
Section 70.
70 is what? Section
Gang
70?
rape, Lordship.
Gang rape.
Uh-huh.
Gang rape.
Gang rape. Okay. So there are two persons.
Two persons.
Show me the FIR. Thing or-
Lordship,
right.
From the
Yes.
closer statement of the main accused, Rabiul
Rabbul.
Rabul.
Hmm.
So he has categorically stated that he was in connivance with the present accused. Lordship, they have forming a network of cybercrime.
He has said,
Yes,
so he
but
was
the
found out.
investigation is in progress, Lordship, and there is, we need some time to get the source of those network, Lordship, cybercrime, because some articles were recovered, Lordship. And he has also implicated the present petitioner, and the role of the petitioner and other associates are yet to be ascertained, Lordship. So his custodial interrogation is very much necessary at this stage, Lordship.
Interrogation, I am ready, madam, I'll extend our cooperation. Everything is sealed, madam, what for custody?
This bail order will not cover your case because he was behind the bars for 52 days.
Yes, Lordship, that's
No,
what.
that is, I'm not, that is the regular bail. I'm not, simply saying, Abdullah already got bail.
May I read his statement,
My
Lordship?
question, my.
His statement, leave it. It is his statement only which
Yes,
led
yes.
the police to him.
Yes, yes, Lordship.
So, but all these Ayushman card, Aadhaar
Yes,
card,
everything has been.
Anyone, madam.
whether it was given for, why was it given to this person by the respective?
People come from the village, they're doing, sometimes it's kept for the purpose of other reason, my lord. But my, well, you also see whether it's fake or not, or any person made any complaint of this person's, my, no question.
The
That
investigation
is, I am
is
on
still in
that,
progress, Lordship.
and everything is sealed.
To honor the
this
modus
is fine.
operandi of the entire network, Lordship, and the role of the persons,
But for it to
how
state,
he's
my lord, and
associate.
Only these two, this Rabbul has not spoken about others.
No, Lordship.
Only this
person,
one.
Lordship, specifically, Lordship.
Only 2% cannot do this.
There are other associates are involved. So to ascertain the roles, we need some time, Lordship. At this stage, I'm vehemently upset. It's not a fit case for granting anticipatory bail at this stage, Lordship.
The FIR was lodged when? 5/26.
Five, FIR was 22, 5/26.
And how come Rabbul was there for 52 days?
Lordship.
You also kind of, they.
No, in the order it is written that he was inside for 52 days.
Forward is report, we have filed forward is report, my lord.
But can it be 52 days from May 22nd? June, July. Oh, yes, it can be.
His bank
60
statements
days.
also so many money has been transactions, money transaction is there in his account, Lordship, from different sources, Lordship.
Bank statements.
Lordship. And some electronic devices, other forged documents are yet to be recovered, yet to be seized.
The section involved in this case, whether the attracted or not.
Sexual involvement?
Sexual breach of trust, then where is the breach of trust point of?
No, that is,
That
public
is
has
public
deposited the,
Yes.
Anybody has filed, it is simple police say, we got the information, co-accused say, but
huh.
anybody say that I have put these things to him and he misappropriated this, or he cheated me. None of them come
Yes.
in a whole case that you.
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. A.K. Azad, learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Colgasia, PS case number 50 of 2026, registered under section 612/318/3162/3162/35 of the BNS 2023. The FIR connected with the instant case was filed by the SI. Who filed it? It was filed by in charge of Hailakandi. What is this? Colgasia.
Yes, case.
In charge of Colgasia Police Station, Borpeta.
Yes, Lordship.
Borpeta. Stating on 22/5/2026, stating inter alia that on a source information, the police personnel came to know that one Rabbul Alamin has been operating a nexus involved in cyber fraud activities in and around the Rampur area along with his associates. Full stop. On receiving the said information, the police personnel conducted a search operation and apprehended said Rabbul Alamin. And during interrogation, and on being led by the said accused person, the police team proceeded to his shop and seized various incriminating articles. Full stop. It is also stated in the FIR that on interrogation of the said person, the police team, interrogation of the said accused person, the name of the petitioner surfaced, and the police team proceeded to the residence of the petitioner and conducted a search. Full stop. However, the police team could not arrest the petitioner, and on reaching the shop of the petitioner, being shown by the nephew of the petitioner, a number of incriminating articles were shown to have been seized from the shop thereof. Full stop. Para. Learned senior counsel for the petitioner submits that none of the victim, if at all there are, has filed any complaint against the petitioner to attract the offense of cheating and other offenses as mentioned in the FIR. He submits that it was the police personnel who, on the basis of the co-accused statement, had implicated the petitioner in the said offense. Full stop. On the other hand, Ms. S.H. Bora, learned counsel for the state, submits that the co-accused, namely Rabbul Al-Amin, had stated before the police that the petitioner is involved in cyber fraud activities. Full stop. She has also placed, she also stated that the bank account of the petitioner also shows various transactions made in the said account. Full stop. On consideration of the submissions made by the counsels of all the parties and on examination of the case record, it is found that the petitioner is implicated in the case only on the statement made by the co-accused, that is Rabul Al Amin. And it is also seen that there is no complaint from any quarters against the petitioner about his cheating the victims, about cheating of any alleged victim. It is also noticed that, that Rabul Al Amin has been granted bail by this court. In the said facts and circumstances, this court deems it fit to enlarge the petitioner on bail, to enlarge the petitioner on pre-arrest bail, on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority under the following conditions. Petition is disposed of.
My objection may be recorded.
Yes, yes. Arrohan Likhiu Diba, she has vehemently objected. I have already written down the.
Authorized. I think.
35.
And the other matter, it will be deferred.
35 is one interim is just CD has not come.
Okay, 35, you're right. Heard Mr. H.R. Chaudhary, learned senior counsel, assisted by Mr. Mr. I.U. Chaudhary, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. Mr. B. Sharma submits that the case diary as called for in the instant case has not been received, and as such has prayed for some time. Prayer is allowed. This matter on 14th of August.
Interim order में करते हैं.
There is an interim?
Yes.
14th of August, interim, then we'll go later. 17th of August, interim order passed earlier shall continue until the next returnable date. Yes. 32 हो गए. Oh, yes, Mr. Kalita. I made you wait for some more time. Yes.
So initially this bail application was filed on the anticipation. Later on, information was obtained that the FIR was lodged and the case has been registered. So in the motion stage, he was allowed to go on interim bail. But allegation is that.
Now he is on interim bail.
Yes, yes.
Lordship, in this case, Lordship, unfortunately.
You are petitioner in person?
Yes, Lordship. Unfortunately, I am the informant as well as the victim here.
No bail.
May I please?
Yes.
The wife of the petitioner, she resides just next door neighbor. I know her from 1985. One fine morning, the husband and wife, who is also residing with his wife in his in-laws' house, came to my residence and just told me that because of some financial constraints, they are now engaging in share market. So persuaded me to invest some amount in the share market. Though initially I refused, but because of their financial condition, I told that yes, as because they can earn some money through brokerages. Accordingly, I have invested 5,000 rupees per month for a period of 3 years. After that, when I inquired in their in-laws' house, I have been told that they have left that place and went to his parental house at Borbeta. I tried to contact the petitioner about 4 or 5 occasions, but he did not pick up my phone. Thereafter, Lordship, I tried to contact his wife. She initially took up the phone, and thereafter, Lordship, we'll pay you, just like this, that, but it is never been paid. On that date, Lordship, when that case was listed, it was placed by my learned friend at the instruction of his client that this amount will be refunded within 3 installments. If your Lordships come to that order, they specifically mentioned 26/6/2026.
Yes.
In paragraph 5.
Yes.
It is submitted on behalf of the petitioner that the petitioner is willing to return the entire amount of rupees 1,80,000 within 3 months. On this basis, Lordship, the interim was granted to him, and that order was of 26/6/2026, and this case is listed today as because within 1 month he has to pay that first installment. But Lordship, Lordship can kindly see that the audacity he has, Lordship. he is making mockery to this judiciary, Lordship. He has made a promise before this honorable court that it will be refunded within 3 installments. And that is why this case is fixed after 1 month so that he can pay the first installment. Not been paid, Lordship.
So
And it is a clear case of cheating, Lordship. Clear case, as because from the very initial stage, his menstrual, he never invested a single penny of mine in the share market. So I humbly pray before your Lordship for rejection of this bail application.
And over these 3 years, you did not know. I mean, when you invest something in the share market, you will get something.
That is
Some
the
information.
fault on my part, Lordship. That is the
Yeah.
fault. Otherwise, Lordship, when I invest some money, it goes to the bank. But here I make the payment, cash payment, some. So that is the mistake I have committed and I never inquired. That is because of my honesty, Lordship, he has done play this foul play. Had it been detected, had I been vigilant, Lordship, at the initial stage, it could not have been done. But being the next door neighbor, I know the lady from the 1985 when we have constructed our house near their house. So, Lordship,
So, okay, your interim order was based on the condition you will
yes,
pay.
Lordship,
it
that
within-
was the concept.
And the remoter, Lordship will find in the page 11, there is an agreement. So he is not disputing that he never taken any money. So he is, CD will also reveal that now he is under some financial constraint. His mother also expired. So my lord, within 3 months, he undertook. I personally,
See,
for my learned friend.
it's not the question of 3 months only.
Lordship.
He had evaded. He left the place. He did not tell him. Right. He did not pay him. He did not receive the phone calls. Now again, you are not paying. It's a continuous process.
And he is playing with the judiciary, Lordship. That is the worst part, Lordship, he has done.
Now we will not believe you that you will need some more time to repay the money.
Actually, my lord, the 3 months has not expired.
Now, the first installment, Lordship, that order is specific.
So may I request, my lord, let this matter be listed after another 1 month, my lord. In the meantime, he will pay, my lord. He has no intention not to pay.
He had no intention not to pay. He had intention
Yes,
not to
Lordship.
pay. Because otherwise he would not have just left his place without informing him, without even telling him what about the money.
gave the-
He could have told him, yes, I will pay you. Give me some time. I am under some financial constraints.
Yes, to my instruction, my lord, he left the interest because he is under financial constraints. So,
No, Lordship, I am not the only person, Lordship, that's because I have seen some other persons are coming to their in-laws' house. There are a chaotic situation at night.
Now, my lord, in Gauhati, to survive in Gauhati, he must have some source of income. So as he has no source of income, he left to his parent hometown. Now, yesterday I talked with him that recently he joined in a company. So, my lord, he has intention that I can say that because at this moment he could not pay. That is my lord, due to his financial. On the first day, for my learned friend, I himself talked with him. And he assured me that is why I assured before his court.
Ajay, you do one thing. Within 1 week, you pay something to him, not 1 month. You pay 1/3 of the entire amount.
And he, yes, I also asked him to talk with him because he also did not want to, my learned friend also want to talk with him. And he also did not.
He fled away, Lordship. He did not even receive my phone calls. If your Lordship
To
sees
my
my
instruction,
history.
in the police station, he has paid an amount of rupees 70,000.
Lordship,
My
those-
When?
Initially, when the my learned friend lost the FIR, he was picked up by the police.
Acha.
In police station, he paid to my instruction.
No,
On his
Lordship.
instruction, I am
It's a false statement. Lordship.
SAB, he picked up and then he got
And
released.
then he was allowed to go.
kept in the police station for 36 hours.
He was
36
there.
hours. Yes, he paid an amount.
Then
he
he
was
can
released.
very well lodge a complaint
his-
against that.
Where is the
That was
complaint
not done.
against
These
him?
are all
What
things
happened to those 70,000 rupees?
Hello?
What happened to that 70,000 rupees?
20,000 to my instruction, he has paid to him.
Lordship, at least I will not in live before this honorable court.
I can say only on the basis of instruction.
And I am not expecting it.
He is
from
not a person to be
such type of
believed.
Submissions on behalf of.
You are instructed, but he is not a person to be believed. Because a case is pending against him, he will not simply be released by the police officer.
No, he was not, at that time, case was not registered. At that time, case was, I have stated everything.
The case was submitted by him, but it was not registered.
Yes.
And in the meantime, he was arrested.
No.
He was
not
picked up.
arrested. He was not arrested.
He was
He was brought to the police station And Mr. Sharma also went there on the next day morning.
Acha.
He was, he was picked up on 10th, my lord. I have stated, on 10th of February.
Huh.
In paragraph 5.
The affair was not lost on that day.
Let me submit now. You have attacked me personally.
I am not attacking him personally,
you-
Lordship,
no,
but
no.
I am expecting a better submission from my
I
learned
will
friend.
submit on the basis of instruction of my client.
No, you were instructed. That is why I
Yes.
said that he is not
What
to
is
be.
my interest?
Hmm. No, no, he did not mean that. He meant
No,
you
well,
were wrongly
when-
instructed. That is what.
So I have, in paragraph 5, I have stated, on 10th of February, I was picked up by the police. Then
Yes.
on the 11th of February, Mr. Sharma went to the police station. Then he paid some amount. Then he was released.
You were
he was
there when
kept
he
in
was there.
36
These are
hours.
These are all afterthoughts, Lordship. To make out a case, Lordship, these are all afterthoughts, Lordship. They didn't show any document, Lordship. I have all the documents that I have. He is not that the person that he will pay me something without there being any document, without there being a signature. He is not like that person, Lordship.
CD might be here, my lord. Let the Lordship.
Yes,
See
anything.
the case that Lordship will pass order.
If that is there.
CD I have sent to you, Lordship.
Yes.
Oh, acha, acha.
But that is the fact.
No,
Lordship, what I have.
the presence of the victim in the police station on
I will have to check it again.
11th.
I will check it. Lordship.
Okay.
That's
This is the
because-
statement of Ritumani Das
Yes, Rintumani does
is the accused.
FIR এখন কেতিয়া লগ দিছে? My only contention is that, Lordship, had he spent a single amount of my money in the share market, thereafter, Lordship, my share goes. I will not lose any affair, Lordship, but from the very beginning, Lordship, his intention was to eaten up my money, Lordship. That was the.
Acha, where is the agreement?
Agreement kindly see my lord, 11. Whether this agreement he can execute, but 24% interest.
Acha, Mr. Sharma, Bhaskar Sharma, just see whether, what about 11th? One party is claiming, other is refusing, so let's see. Yes.
I also, my lord, initially, my lord, I also wanted that Mr. Sharma got his amount. Yes, because he also admitted that money has been taken. So, my lord, it is hard-earned money. I asked him that pay him the money. And he sought some time as he was suffering from financial crisis. He assured me yesterday night also I talked with him. So personal letter is not good.
But then his statement is wrong. He said before the police that he did not reveal to Mr. Sharma that he will invest it in the share market. But in the agreement, it's written it's share market.
Yes.
That incorrect statement he made before the police. He said, I took the money for my own expenses. Later on, I invested it in share market. See his statement?
It's not there, Lordship.
Not there.
Is GMP given up in this?
The FI was not registered, so that time they will not put anything in the. So, okay. Uh, So within 1 week, you make some payments. According to the agreement, he is entitled to get 2 lakh something. But now he is claiming only 1 lakh
Yes,
80,000.
Lordship, I not want the rest. I want
Interest
my
amount.
hard-earned money, Lordship.
Return the entire money of 8 lakh 80,000.
Even he has assured only 1 month back that he will make the payment within 3 installments. They make this, and because of that, this honorable court has fixed this matter on 27th. That earlier, the case was listed on 26th of June. That 1 month time was given to him so that he can make the 1/3 payment. So he is playing with the judiciary also.
And he is making incorrect statement before police also. Not to be believed. Don't believe his words. Okay, what I'll do is within 1 week, he should make some payments.
Let it be 15 days.
Okay, 15 days.
Let it be 15 days. Let it be 15 days.
days.
I also wish he.
Yes.
So that he can get.
But 15 days, you should not come. That saying that, no, I am financially unstable, I cannot pay that, you cannot say.
I can only compel, I cannot compel him.
No, the petitioner.
Today morning also I told him that I cannot compel him. I can only submit on the basis of his instruction.
That is why, Lordship, I am saying that even he has that audacity to play with the judiciary, Lordship.
And it is my duty.
How dangerous
to
this
defend my
person
client.
is.
Okay, okay, heard Mr. N.K. Kolita, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state, and Mr. R. Sharma, Rishikesh Sharma, learned counsel for the learned informant appearing in person. It is noticed that that on 26/6/2026, this court had granted interim bail to the petitioner only on the ground that the petitioner should pay the entire amount of 1,80,000 that he has taken from the informant within a period of 3 months on installment basis. It is also noticed that the matter has been listed after a month only to enable the petitioner to make the first installment within a period of 1 month to the petitioner. However, when the matter is called up today, it is submitted by the learned counsel appearing for the petitioner that he could not pay the first installment or any amount to the petitioner due to his continuous financial constraints. But it also cannot be loss constraints, full stop. It cannot be lost sight of the fact that the informant is entitled for an actual amount of, how much was the amount? 2 lakhs, what agreement? Where is the agreement you had shown?
Agreement.
Yes. Amount of 2,56,121. As per the
1,80,000.
as per the agreement reached between the informant and the petitioner on on 1st July 2022. However, in the last order, it is stated that the principal amount to be paid to the petitioner, paid by the petitioner to the informant. it will not be out of context to mention herein that the both sides has to be balanced in the instant case. For the interest of justice, this court further directs that interim order dated 26/6/2026 be further extended to another period of 15 days, by which time the petitioner should pay at least 1/3 of the entire amount of rupees 1,80,000 to the informant. It is as such, it is directed for the simple reason that the petitioner has admitted that he has taken the money from the informant and that he is duty bound to return it. As per the agreement, the petitioner was supposed to return the entire amount of money along with the interest. In the first part of June 2025. But till date, not a single penny has been returned to the petitioner. This is a bail matter. In bail matter, such kind of an order. Right. Acha, petitioner has appeared before this, no? He had given his statement. Acha, for that you have to file something else. This is a bail jurisdiction. Right. That this case will continue, cheating will be proved. By the last order, it was not directed that you have to pay it. It is a submission made by the petitioner.
Yes. That is why I'm saying, Lordship, in the court, Lordship, the submission was made that in 3 installments, the payment will be made. That is why, Lordship, the first installment within 3 months. That is why on 26, the case was listed on 26, and the case is listed today, that is on 27th. 1 month period so that he can make the 1 installment. But my whole contention is that he's playing with the judiciary, not only with me.
As far as he's following the conditions, he has followed. He has appeared before the IO, he has given his statement rightly, wrongly. And he will continue doing it. But in this bail jurisdiction, I don't think so I can pass such an order. Only that I can write, he has given his undertaking, but then he did not comply with it.
Undertaking, that is also perhaps that is not there, the first installment will be.
No.
That is also not there. So,
it is implied.
Yes, still I am submitting.
That is, yes, Lordship, that is why I'm saying that, yes, Lordship, my learned friend is praying for 15 days time. Let it be 50, let the matter be fixed after 15 days.
His benefit I am submitting, madam. Otherwise, my lord, this court cannot act as a recovery agent.
As far as bail, let him be on bail.
That interim may continue, Lordship, let it be fixed after.
No, interim is continuing. Acha, Dapa Pohasan, ki kolu interim order pa? Nalage. Another 15 days, full stop. It is stated that although the petitioner on the last occasion had submitted that he will return the entire amount of rupees 1,80,000 within a period of 3 months, but till date, he has not given any money to the informant. However, as far as the conditions ascribed in the bail petition is concerned, as far as the conditions prescribed in the bail petition is concerned, the petitioner has fulfilled the same by appearing before the IO within the stipulated time, and his statement was also recorded. Please just, okay, I'll think over and I might change also.
Lordship, in a
Please
bail
just-
appeal, it's your lordship discretionary power, lordship, either to accept it or reject it, lordship, the bail.
Hmm.
But even then, lordship, my learned friend is praying for 15 days time, let it be after 15 days, lordship.
But this court cannot keep on monitoring, you pay it,
Yes,
and
yes,
again you pay
that
it.
is true, that is true, that is
So
true.
as far as the bail is
So, but
concerned,
but it's a good case on my humble submission, it's a good case for rejection. As because they're cheating, that the now the BNS 318(4) is proved.
it will be proved in the trial stage.
No,
Not
lordship,
now.
lordship, lordship.
It is
But
a.
lordship, it's a discretionary power, lordship, whether the bail can be granted or rejected.
No, they're cheating. He has to, I have to be satisfied about the previous part, the intention part from the inception. He admitting that yes, he has taken money and he will return it back shows that he did not have the intention to borrow your money. So the cheating will not apply.
No, lordship, that mens rea was there at the, had there been some investment, in that case, yes, there is no cheating.
Okay, we will see it. List
Lordship.
this matter okay, calculate 15 days from today. And list this matter on 27th, right? 27th, 31st, 7. On 10th of August. 10th of August. No, not 10th. 10th will not be 15 days, right? 10th, 31st month. 11th of August.
Lordship.
Or make it 12th.
12, let it
12th. 12th of August 2026. I will think over, I might change something. Otherwise, Mr. Bishop Sharma, what are the materials against him in the case diary?
Only that much only.
Only that much. He is also agreeing he has taken money. He has to repay, but he is not able
It was
to.
already gone to the statement made by him. He has agreed also that part.
So only way he can get money is by filing money suit.
That I cannot.
That, yes, lordship, that.
For them.
That is why, well, I'm, let
No,
him
no,
cooperate,
lordship.
madam, let him
No, no,
cooperate.
no, I am cooperating,
I'm trying.
But when,
I have
lordship,
representation.
I am the victim, lordship. When my learned friend is submitting on behalf of the petitioner, naturally, lordship, some
Okay. Chala.
much obliged.
36.
Interim to continue for another 15 days.
36 looks like petitioner is on interim, CD has not been received.
Uh-huh.
Petitioner is on interim, CD has not been received also.
Oh, here.
Yes.
And what about the alia matter? You will retain the CD or what?
As your lordship directs, I can keep it. And
The
I-
case diary be retained till the next date. Okay. Yes, here. Okay.
CD
Heard Mr. N. Uddin, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. The Mr. B. Sharma submits that the case diary has not been received and has prayed for some time. Prayer is allowed. List this matter on 17th of August 2026. The interim order passed earlier shall continue until the next returnable date.
lordship. Same pair lordship.
Oh,
Interim is there,
এখানে
CD has not been-
HRA Chaudhary case. Yes. Here also heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. Bhaskar Sharma, learned APP for the state. Mr. B. Sharma submits that the Case diary has not been received and as such has prayed for some time for placing the same. Prayer is allowed. List this matter on 18th of August 2026. Interim order passed earlier shall continue until the next returnable date.
For 30, my name may be recording notes.
Same. CD not received.
CD not received.
Okay, heard Mr.
US Bora.
US Bora.
US Bora.
US Bora, learned counsel for the petitioner, rest will be same.
For any petition, my lord, again, the same family members, my lord.
Acha, what happened here? AB case diary is there?
Petition number 5 is already released on interim bail, my lord.
Is already on interim?
On
Only
5.
only 5 is on interim, lordship.
Acha.
Others not interim, my lord.
So, injury report was called for.
Found the one family member.
Hmm?
Petition number 1 and 5 are the husband and wife and 3 are son, man. 2, 3, 4.
So 5 is released on interim bail,
Yes.
not the others.
No.
4 persons are still AB, okay.
Anticipatory.
4
bail.
persons are yet to be enlarged.
Yes, lordship, in the earlier occasion, injury report in respect of Imran Nazir was called. for.
Informant.
No, lordship, injured person's report, medical report.
Acha, of the informant or injured person is from the informant side.
Yes, lordship, yes.
So medical report is here.
Yes, 3 persons got injured, lordship. So far as the main injured person, his name is Imran Nazir.
Hmm.
His report was called for, that is awaited, lordship.
Imran Nazir's report has not come.
Not come, lordship.
That is the main, I think,
Yes,
medical
that is the
report which
main-
is required.
Yes, main
My lord,
report.
this is a land dispute, my lord. The Ezahar Kari informant themselves, a mob of people too can forcefully enter into their land and trespass land and.
It's okay, but we will
come, lordship.
no, we will go into the merits, but let
Let the report come, lordship.
the report come. We will go into the merits.
In the meantime, my lord, interim may be given,
No,
otherwise,
not at
my
this
lord,
stage.
they are facing so many problems.
No, I'll give her a short date. Let her bring it.
Yes,
Family members, my lord, all.
When can you bring? Friday?
Lordship, today is, okay, Friday. lordship.
Friday. Heard learned counsel Mr. B. Islam for the petitioner and Miss S.H. Bora, learned APP for the state. Miss S.H. Bora submits that the injury report of Imran Nazir has not been received and as such has prayed for some time. She, however, submits that the injury report in respect of the other 2 injured person are, however, received. List this matter on
Let it be on 27 or
27th
No.
is what?
let it be.
Monday.
On 31.
No. 27 is today.
Let it be on 31, lordship.
31 years Friday.
Monday, lordship.
No,
Next Monday.
July 31 is
Thirty-
Friday. Monday is 3rd.
Yes, 31, lordship.
31st, list this matter on 31st of July 2026, on which date learned APP will place the injury report of Imran Nazir.
Lordship.
Full stop. Interim bail of petitioner number 5, namely Saleha Begum, is extended till the next date of listing.
And CDB retained, lordship.
CDB retained till the next.
Only injury report is called for.
Only interim of R5.
Petitioner is more affected than the informant matters. They are more,
It's okay. On Friday only another 4 days to go.
there is cross affair.
Obliged, lordship.
Hmm. You are on interim.
Yes, it is not received, Lord.
CD?
Not received, Lord.
Not received.
Yes,
Did you
but
go for?
instruction, we have appeared to the police station.
But then, okay, let the CD come. I'll fix it on Friday.
They are on interim, Lordship.
Okay. Heard, Mr.
K. Bhattacharya.
K.
K. Bhattacharya.
K. Bhattacharya, learned counsel for the petitioner, and Mr. B. Sharma, APP for the state. Mr. B. Sharma submits that the case diary has not been received and as such has prayed for some time. Prayer is allowed. List this matter on 19th of August 2026. Interim order passed earlier shall continue till the next returnable date. Oh, yes. Mr. Bora.
The PRS bail application, my lord.
Case diary is there?
Yes, Lordship.
My lord, petitioner before lordship is a government Gauhati, my lord. Lot number 9, Nis Silabanda Gaon, my lord. There's a
Petitioner is the government Gauhati.
government Gauhati, my lord. My lord, FIR lost, my lord, on 6/6/2000 page 14, my lord, your lordship, my lord.
Okay, let me read the FIR myself.
Can I have a vernacular, my lord?
No, it's okay.
Yes, ma'am. With due
I'll read
respect.
it myself, Mr. Bora. I'll read it myself. She's committed suicide.
Yes.
She died.
Yes. Problem is my
Gaon Pradhan.
if that says.
Gaon Pradhan was present there.
But even with the Gaon Pradhan present, where did they get attempt to beat my wife? This is
No,
the
Mr. Sharma, let Gaon Pradhan be on bail.
my lord, I have.
He was called by the family members of that clan. He went. And he cannot control ladies beating up.
Ladies, how can I?
He cannot
I
control.
specifically mentioned, and my lord, DC also inquired the matter because of the I am the Gaon Pradhan, and DC report is also there, my lord. Page 20, my lord. And report is page 22, my lord.
22.
That from the inquiry of the nearest Gaon Pradhan, we have come to know that the allegation that Gaon Pradhan under pretext sitting a domestic dispute called a woman named Rumi so-and-so.
Completely false. Yes, without going through, one can say it is false. Okay. Yes. Heard Mr. Niran Bora, learned counsel for the petitioner, and Mr. Bhaskar Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Jamuguri, PS case number 52 of 2026, registered under section 108, BNS 2023. The FIR lodged in the instant case was filed by one Rajiv Saikia reveals that his wife was having a friend that his wife occasionally used to speak with one Vishnu Das, and that the wife of said Vishnu Das suspects that wife of the informant had a relationship with said Vishnu, and that on 4/6/2026, the mother-in-law of Vishnu called up the wife of the informant and called her to her place where the wife of Vishnu Das was staying. And when the wife of the informant reached the house of the mother-in-law of Vishnu, she saw a wife along with her mother, Bilidia. She saw the petitioner, who was the Gaon Pradhan, and several other persons assembled in the house of the mother-in-law of Vishnu. And on her arrival, the mother-in-law and sister-in-law of Vishnu, as well as wife of Vishnu, attempted to beat his wife, that is wife of the informant. Full stop. The informant therefore stated that in the presence of the Gaon Pradhan, how can the female of no how can the relatives of Vishnu can beat up his wife and his mother-in-law. It is also stated in the FIR that the relatives of Vishnu had called the wife of the petitioner along with her mother on the next day and threatened her that they would burn down her house and property and would defame her in front of everyone. Full stop. The informant thereafter stated that unable to bear the insults, his wife committed suicide. Full stop. Para. This application is, however, filed for bail of the Gaon Pradhan. The learned counsel for the petitioner submits that said Gaon Pradhan, that is the petitioner, was called by the mother-in-law of Vishnu and other relatives, and he had simply went to her house on being called. Full stop. He had no connection with the assault made on the learned counsel stated that the petitioner has no connection with the assault made on the wife of the informant. The learned counsel has also placed the report of the circle officer, the report of the DC, the report of the
Circle officer forwarded to the DC, my lord, on the
Okay.
basis of, my lord, page 20, my lord,
for an inquiry.
inquiry, my lord.
22 speaks of inquiry done by whom?
Done by the circle officer, my lord. Circle officer, my lord, appointed some inquiry officer, my lord, regarding this, my lord.
Acha. So this inquiry officer is land revenue assistant.
My lord.
কি করলো? Also placed a report of the land revenue assistant who was directed to inquire about the actions of the petitioner. And in the inquiry report, it was stated that the allegation against the petitioner is false. Allegation against the petitioner which led to the suicide of the informant's wife is false. Mr. B. Sharma, learned APP, stated before the court. Case diary is there, right? Mr. B. Sharma, on perusal of the case diaries, stated before this court that there is no allegation against D, right? Or I say there is allegations.
There eyewitness lordship, there was some altercation and some abusive language was used. Lordship.
He stated that the witnesses were present and they had stated before the police, the investigating officer, that the petitioner was present when the assault on the wife of the informant was going on. Full stop. On consideration of the submissions made by the parties, and more so on perusal of the case diary as well as the other documents on record, this court finds it fit to enlarge the petitioner on bail, on anticipatory bail, on pre-arrest bail, on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority under the following conditions. The petitioner should appear before the investigating officer as and when called for. The petitioner will not influence the witnesses connected with the case. Petition is disposed of. Yes, Mr. Kotoki. Sorry, I made you wait for so long. এখানে হয়ে গেল নাকি? Bail may not go. আচ্ছা. Yes, Mr. Kotoki.
Yeah.
Yes, that is there, received.
It is received.
Yes, Miss.
It is a application of taxation. For intercepted bill 482 mile.
Huh.
The case register section 406, 420 and 458 and 471.
All cheating, forgery.
Forgery. What
Where-
is the lots of handling come to the FIR matter?
Huh.
This petitioners are middlemen actually.
This
That the lots will find the FIR at page 13 man.
15.
15 man. Was
What
brought
is-
by one Abdul Sohid man.
Sheikh Abdullah, and what is the name of the other petitioner?
Sheikh Abdullah and Adim Uddin Singh. They are middlemen. Man.
Hmm.
They are a petitioner. With due respect, I feel I am the lawful owner and possessor lot of land situated at Food Terminal Potter and Adwa Musa, which is under my position. It has come to my knowledge. Below name accused persons with a malicious and dishonest intention have illegally and created fraudulent and forced land documents regarding my property in my absence. By using the spoke documents, accused person has sold my possessed land to innocent third parties, like Asma Begum, number 2, Moinuddin, number 3, Nazrul Haq, and misappropriated a large amount of money. On 1/6/2026, about 3 p.m., after coming to know about the same, from the said innocent people, I along with the sign immediately made the accused persons regarding the illegal sale and questioned them about the false documents. They became aggressively and directly threatened me and my son with dire consequences if I pursue the matter. I've learned that this the accused person has as a
Standards, models, and-
opponent if I forging on document. Now your lordship will file. Actually, what happened, the occurrence took place, actually, there was a.
But this middleman creates lot of problem. They show that these
No,
land
but-
belongs to this,
What
that.
happened, there was a agreement for sale minor,
Huh.
that I'm in my, and this is affidavit. I have enclosed.
Okay. Hmm.
I have not received the additional copy also.
I will give it.
Additional
There
affidavit.
is a
We
Caesar
have
list
not
minor.
received.
It was
Let
a-
me see what is there.
I
Huh?
see the Caesar list minor, it was these, the persons, the sellers, they have executed, they have given the agreement, copies of the agreements for sale minor.
This is what they have forged.
No, no, not full. There was no signature in forged minor. Now, on the basis of the agreement sale, position was given to the seller. They have, and the.
Purchaser.
Purchaser, and the seller has received the money, man. But then they applied for sale permission. Your lordship may kindly see the sale permission.
Hmm.
That sale permission I have enclosed, your lordship will find at page, lecture 3, page 18 onward. Up,
18.
18, and lecture 3.
Hmm.
That sale permission, it was name of the informant, man. After receiving the money, he has put his signature.
Wait, let me, what is the name of the informant?
Abdul Sahid.
Huh?
Abdul Sahid.
Abdul Sohid. So, yes.
Yes. So-
Abdul Sohid.
So he has signed it and according to Deputy Commissioner has issued sale permission minor. Next page also your lordship will, Abdul Sohid in name of Sahina Yasmin minor. Earlier was on Monora Begum minor. Then again Abdul Sahid with Siana Yasmin minor on 19/7/24 minor. Then altogether his brother also sold it minor. They have also that is Tan Mia minor, his brother minor. Again Azimuddin Sheikh, it was permission was granted.
Hmm.
Again, Salma Begum, that your lordship. But what happened, minor? Even after obtaining of sale permission, he did not execute the sale.
I mean the Abdul Sohid.
Yes, minor. So they
But see, the name of Abdul Sohid is also different here.
he did not execute the sale deed, or they filed a title suit, man. The occupiers, man, they filed a title suit, your lordship, that title suit, now I have got a copy of the title suit, minor.
No, they were shown these documents
Yes.
that Abdul Sohid has sold it to them.
Yes, ma'am.
So they wanted,
They,
see,
now, this.
they have filed title suit for
Yes.
specific performance.
The payment because no,
Huh.
they.
But these documents are stated to have been made by the accused person.
No, not by, by his signature. In the title, so there is a environment, my lord, that Abdul Sohid has taken money, man. Abdul Sohid has taken money for by executing, you're supposed to execute a sale deed. He applied for sale permission, but he did refuse to.
No, these were all projected to the purchaser.
No.
That Abdul Sohid had
No,
taken
Abdul-
money.
No, your lordship, the environment in the plain, my lord. There was initially agreement was made with Abdul Sohid, my lord.
It was shown to have been made, but it was made by the petitioners
No,
by
no, no,
forging.
no. In presence of Abdul Sohid, it was done. Petitioners acted as a middleman, no doubt. But actual money was paid to Abdul Sohid. And that for that purpose, sale permission, your lordship may kindly see that in the plain, copy of the plain.
Okay, where is that?
That I don't have the, you know, the next with a copy, my lord, that your lordship will kindly see.
But this agreement for sale at page number 28 is between Akhtara Begum and Azimuddin Sheikh.
As you-
Yes,
that is the
yes.
middleman, that's the middleman.
The present petitioner, one of the petitioners.
Middleman.
So,
The letter on man of sale permission, one to sale permission was obtained, then after receipt of money, then that your lord, then thereafter, my lord, he did not execute that, he's, they file a title suit.
where is the title suit?
That your lord, that. No, question of forgery doesn't arise, man. No document has been forged, man.
Title suit you have not annexed with this?
No, it was, I came to know it around.
Okay.
Title suit was filed in way back in 25, man.
Again, sale is Sheikh Abdullah, that is the petitioner. Agreement of sale was between the petitioners,
Petitioner and the purchaser.
purchaser,
And
not
select-
between Abdul Sahid.
Not up. After he was supposed to sign the sale deed, but he did not sign the sale deed after obtaining the permission. After the
Then-
sale permission obtained,
Sale permission was not obtained.
it was obtained. That I have enclosed the copy of the sale permission.
Where is that sale permission?
That your lordship will find at page 18, mate.
18. Oh, yes, that you have shown.
Abdul Sahid, son of Akas Ali, it was a favor of Munwal.
But here the name of the owner is different.
Yes, Lordship.
The name of the
Buyer is different.
but they are different buyers. Then your lordship will find, next buyer is by your lordship will find, that is Sahina Ismin, that Abdul Sahid, the owner is Abdul Sahid and purchaser is Abdul Sahid. Sahina.
Purchaser is Manuara Begum.
Purchaser Manwara Begum. Second one is the spot, the plot of land is only 11 less as mine. One plot of land, mine. Then comes
Then to so many parties.
different parties, mine. There. It was around 1 bigger land.
Acha, amongst the 1 bigger, he has sold 11 acres to Manuara.
Manwara. Then again another 5 lesser to
1 kata 5 lecher.
1 kata 5 lesser to Sahina Yasmin. Then again to then this was on 22 miles. Then again sale permission was revised on 24 miles. Same was revised pilot
Where is this place? Hojai.
miles. But he did not execute the sale bid.
But rest of the sale deeds are of Chanmia. You have given only 2 sale deeds as sale permission of Abdul's 3.
3 miles. 3 sale permission.
Where again the name is little different. Of course, father's name Telis. And why did you annex this Abdul Chanmia?
Chanmia is his brother, mine. His brother also sold the land. Son of Akasani. He's a brother of the informant.
That is not required.
That is, but the same plot of land there, some portion has been sold by the brother. That is
So
what-
where is the plaint? This is the plaint.
Yes.
Plaintiffs are so many numbers.
Yes, all the plaintiffs have filed a case.
For specific performance.
So for directing the defendant number one, that is the informant to execute the sale or return the money. For degree of specific performance. And it was filed in 25 by 2025. So in 26, in order to make out a case, he has lost his FIR.
Where it is that they have given money to Abdul Sahid personally.
There is a statement in the plain.
Where is it?
Then I can show you.
Show me that. Any personally they have given the money, not to these 2 persons.
No.
How can the agreement for sale can be
Yes.
entered between the
So many
broker and
agreements with different persons, Lordship.
broker?
Broker.
I'm appearing for the informant.
Acha, let him finish one
Yes.
second. Let him show whether the money was personally given to the owner. If these purchasers say that I have personally handed over the money to the owner, then it's okay. They must have given money to the brokers. Yes, till he finds out, yes.
The operation in which this entire thing is being carried out is said, I am the bona fide owner of a plot of land measuring 1 bighas in scale. Your Lordship. What they will do is, they are professional land brokers, so they will come and say that they are executing a sale deed, agreement for sale. They're executing an agreement for sale, and once the purchaser money is blocked, this is the language they use. They will block the money of the purchaser by saying that this is the plot of land. Once that money has been blocked, now the
Blocked?
purchaser's money, Your Lordship, with the idea that they are going to purchase a particular property. So they will take a certain amount of money, and then the promised property will never be delivered. What they will do is, they will go and show that this property, since there are some problems with the sale permission, this and that, we'll try and sell you this other property, this other property. In the meantime, the main bona fide owner, even if he wants to sell his land, he is also not allowed to sell his land. They are creating such a sandwich between both the sides that all the money will never be exchanged between the original buyer and the seller. And in the meantime, they will try rotating this money in other properties which they intend to sell, using the name of these particular people who are definitely laymen, and the targeted victims are people who do not understand official documents properly, who are either laymen and have some amount of property which they are in dire need to sell. So this is the entire arrangement. Their idea is not directly to sell to the purchaser the property which they have promised in the agreement for sale, but they will try to navigate them and create such a situation so that they can sell some other intended property in some other value. This is the entire plot which is happening. And not just
So agreement of sale can be entered between the broker.
that is another question of law and question
How
of
can
law.
that be? Agreement
That is
for
not-
sale will be between the owner and the purchaser.
And statement of the victim given same sort of allegations as my learned friend has stated, Lordship.
Let him show if he can show that money was given personally to the owner.
Once they take the money from the purchaser and he is in great desire to get the property somehow, and the other party also wants to sell his land, in the meantime they rotate this money, and after 6 months or 1 year, the money is gone, the property is gone, everything is gone.
In
So
fact,
They means they search some other buyer, some other seller.
other
they-
plots.
Other plots, Your Lordship. This is let's say they sell some government plot also. Let's say when there is Myadi Patta plot which they cannot sell, so they will say that there is some reserve land which the government will give.
No,
to
these two are done by the brokers.
Yes.
This is the entire case.
The victim has given such statement, Lordship. May I read one of the statements, Lordship? মই গৃহিণী হওঁ যোৱা ইংৰাজী 11/4/2019 মই পদকীয়া শ্বেখ আব্দুল্লাৰ পৰা one of the petitioners পূব ধনীৰাম পথৰ so দাগ মাটি পট্টাৰ ইমান নম্বৰ দাগৰ খালিতলি শ্ৰেণীৰ অংশ 10 লেচা মাটিৰ মূল্য 2,50,000 টকাত বিক্ৰী মূল্য সাব্যস্ত কৰি অগ্ৰিম বায়না. So she has given an amount of rupees 1,05,000 in advance to the petitioner, Lordship, one of the petitioners. সমজাই দিওঁ আৰু বাকী 1,45,000 টকা আমি উভয়ে চৰকাৰৰ পৰা মাটি বেচা কিনা অনুমতি পত্ৰ লোৱাৰ পাছত ছমাহৰ ভিতৰত দিব আৰু পদকীয়াজনে মোক উক্ত মাটি বিক্ৰী ৰেজিষ্ট্ৰি দলিল সমজাই দিব বুলি কয়, কিন্তু পদকীয়াজনে আজি পৰ্যন্ত মোক মাটিত সমজাই দিয়া নাই আৰু কোনো ধৰণৰ বৈধ no valid, neither he has given the plot of land to the
Because sale permission was not
not done
entered.
because it has been blocked. And say same sort of
So they were in
allegations
possession.
are given by different
They were given possession.
different
The purchasers.
Yes, ma'am. They were given possession.
money is not given to the actual owner, Lordship.
They were given.
Money is given to the brokers.
Anything can be done by the brokers.
Money is given to the brokers. And there are some forced agreements between different buyers with the present petitioner has been.
Okay, Mr. Kotoge, bail should not take so long. I'm not
Okay.
giving,
I'm giving.
I'm not
Can we go
giving
through
bail.
No, no, you understand that because it is the admitted case of the plaintiff, the sellers, the purchaser, that we have given money to the defendant of.
No, show me that. Where is that? Where that he has given money to the informant?
Informant and his brother.
Where is that?
Martin.
Notice?
No, no, no.
No,
no.
no.
Next.
Here, there are so many marks.
Yes,
Where?
all that payment of money has been given. Otherwise, you will not have signed the sale permission. The sale permission has to sign by the owner.
I'm on the same page with my learned friend, what he has stated, Lordship.
Moreover, your lordship,
Wait 1 second. So say what he is saying, the purchasers are saying that they have given the money to defendant number 1, that is the owner,
that lordship,
to cause deed of sale agreement on behalf of performer defendant number 5.
I will brother man.
Performer defendant number
I will
5.
brother.
Variance in the rate, but then okay.
Actually, that is a problem. It was
There is variance.
variances and actually that's why the sale is not done. So it's purely a civil dispute matter. No? Unnecessarily wait.
Sale permission was also given by the deputy commissioner.
the lordship with regards to the plaint and the title.
And I received notice also. 35 notice. I appear. But statement was recorded also. Even the police is harassing me.
Your lordship, with regards to the plaint and the title suit, that averment has to be made unless and until I am being called as a witness, because if the averment is not made, then the title suit would not survive the test of maintainability, your lordship.
Yes.
For only that purpose, the averment is there. Now, averment will be verified at the evidence stage, your lordship. Till the evidence stage, some criminal liability cannot be set aside saying that there is a civil case pending, your lordship. That is our case at large, that the averment, and when we will submit our documents, will come to the conclusion whether we received the payments or not. And if there is a permission, which I am correctly submitting for this honorable court, that there is a sale permission with the same intent when at the start they say that we have taken some amount of money in the behest of this particular plot of property. Now your property will be valued extra, we will get a more amount of value from some other purchaser, therefore you sign this sale permission, and thereafter will sell this property at a higher value. This is the entire criminal liability of forgery and fraud which is happening.
Yeah.
That signature itself will not prove that this is a correct averment or a correct statement, or there is no liability with regards to criminal intent, your lordship. This is our case at large.
Okay, heard Mr. Kotoki, as Saurav Kotoki, learned counsel for the petitioner, P. Kotoki, learned senior advocate. Learned senior counsel assisted by Ms. And Kashyap, learned counsel for the petitioners or one, petitioners.
Two petitions.
And Ms. S.H. Bora, learned APP for the state, and Mr. T.L. Oscar, learned counsel for the informant. By this application, the petitioners have prayed for bail in connection with Hojai PS case number 134 of 2026, registered under section 406/420/471/506/34 of the Indian Penal Code. The FIR registered in the instant case was filed by the owner of a plot of land, namely Abdul Shahid, wherein he had stated that he is the owner and he is the owner of the said land, and and the land is under his possession. But it had come to his knowledge that the petitioners, with malicious and dishonest intention, have illegally created fraudulent and forged land documents with regard to his property. Full stop. He further stated that by using the said documents, the petitioners had sold his land to innocent third parties and had misappropriated a large sum of money from them. Full stop. The informant further stated that on 1/6/2026, he came to know from the said innocent purchasers the full stop. The informant further stated that the petitioners use petitioners use a certain modus operandi to cheat the innocent people by purchase and sale of land of legitimate owners. Learned senior counsel for the petitioner submits that the informant had land and he had sold the same to the purchasers and had received the money from them, and that permission for sale was also obtained by the informant from the office of the Deputy Commissioner. The learned counsel further submits that title suits were filed by the purchasers for specific performance of the contract against the owner, that is informant of the case. The learned counsel as such submits that the petitioners are simply the middle persons who had helped in selling the land by the owner and purchase of the same by the purchasers. He also submits that in the title suit, it was stated that the purchasers had given money to the owner of the plot of land. That is the informant. Para. Ms. S.H. Bora, learned APP for the state, however, submits that agreement for sale has been entered between the seller and the petitioners, whereas the agreement for sale has to be between the owner and the purchasers. She submits that the owner had categorically mentioned that he was in possession of the said land and he had never sold the same to any parties, and that the petitioners have illegally sold the land to the innocent purchasers. Mr. Laskar, learned counsel for the informants, submits that the petitioners, who were the middlemen, used to cheat the innocent sellers as well as the owners by following a standard modus operandi. He submits that the informant had never sold the land to the sellers and that he is in the possession of the plot of land. He submits that even possession was not given to the sellers.
Statement of different witnesses also reveal the same, Lordship.
Statement of the
Witnesses also reveal the same, Lordship.
Miss S.H. Bora Diba, the statement of the witnesses also reveals the said illegal act done by the petitioners.
Money has been taken by the
Petitioners. Having considered the submissions of the learned counsel, this court finds the following. In the in the FIR, it is clearly stated that the owner was in possession of his land, that is 1 bigha, 3 katha and 13 lechas. And that the petitioners had created fraudulent and forged land documents and sold his possessed land to third parties and had taken money from the third parties Full stop. In the title suit, it was stated by the purchasers that agreement for sale has been entered with the defendants, which includes the petitioners, and the price was settled. And it was also stated that defendants had executed a deed of land sale agreement and had accepted amount of rupees 25 lakhs as advance money. And thereafter, the defendants, which includes the petitioners, has accepted more amounts later. It is also seen that the agreement of sale has been entered into between the seller and the petitioners and not the owners. In view of the above facts and circumstances, and in view of the allegations made in the first information report by the owner of the said plot of land, this court does not deem it fit to release the petitioner on bail. The petition is as such dismissed.
Highly prized option.
This is a modus operandi. We all, at this stage, At this stage. Try next time. Let's see how the title suit goes. Yes. এখন দি দিয়া একটু অ্যাসেজ পড়া 42. Yes, Mr. Yes, Miss. Yes, Miss Singh, Dave.
Section 482,
Huh.
washing of the FIR of Bagbajar PS case
Acha.
for 93, Your Lordship.
For quashing of a fire.
Yes, Lordship.
And the investigation is stayed or something?
Yes, no coercive.
No coercive. Okay. And the case diary is required, or it has come, or what?
Lordship, TCR call for lordship that we have
Acha.
received.
TCR is received.
It is FIR, not charge sheeted, Lordship.
Oh, then what? Then it will not be TCR.
CD was called for last page, Your Lordship. And probably because of the.
Case diary of Panbajar will be required for consideration.
Lordship.
Case diary of 93 of 2024, it's there.
Lord, not, perhaps it is not there, Lordship.
No, with you.
No, Lordship.
What are you carrying? This is not.
Lordship, only a TCR call for Lordship, scan copy of case diary. Perhaps it has come through registry, Lordship.
No TCR here.
CD was called.
CD was for,
Yes.
We have not received, Lordship.
Because
On perusal of the office note dated 16/5, wait, 16/5. Yes, fresh notices upon respondent number 2.
5/6.
Service report on respondent number 2 is required.
Already notice was issued, but I did not appear.
Okay, it is delivered to the addressee. And then
Then thereafter, there is an order, it is,
nature of it, the case diary of so-and-so is required for consideration.
Lordship.
Hence, additional public prosecutor is required to produce the case diary
Lordship.
on the next date fixed. List this matter. Who was there? K. Bosho.
Lordship.
So case diary is not
Not
there
received,
today,
not-
so we'll have to again defer it.
But it's so urgent because it is relating to one advocate, Lordship.
I understand, but then the case diary is
Yes.
called for
I-
without following this.
A short date may be given.
Okay.
On,
Okay. Heard Miss M. Dave, learned counsel for the petitioner, also heard Miss.
It is not communicated earlier also because.
Okay, you bring it now.
Yeah, Lordship.
Miss S.H. Bora, learned additional public prosecutor for the state. On the last occasion, the case diary relating to the Panbajar PS case number 93 of 2024 was called for through the learned additional public prosecutor. But when the matter is called up today, it is intimated that it is placed, it is stated that there is some miscommunication and that the case diary could not be called for. Full stop. As such, a prayer is made for giving some time to place the case diary. Prayer is allowed. List this matter on 3rd of August, next week,
Lordship.
Monday,
Monday.
3rd of August 2026, on which date the learned additional public prosecutor should place the, it is Panbajar only,
Lordship.
place the case diary. List this matter accordingly list this matter. Interim order passed earlier shall continue till the next returnable date.
Okay.
Yes, 43, what? Suspension?
Yes, 4 years punishment, my lord.
Acha.
He is under now, my lord, 13 months. Already in 13 months.
13 months. 4 years.
4 years. Under section 326.
326 is hurt.
Yes.
Grievous hurt.
Previous heart.
So what are your grounds for suspension?
Yes, my lord. In my appeal, my lord, I have any judgment, my lord. In judgment, my lord.
What judgment? Impugn judgment?
Criminal appeal.
Impugn judgment?
Yes.
Yes. No, what are your grounds for suspension, I'm saying?
Yes, my lord. In my lord, there is no eyewitness, my lord. And my lord, injury is, my lord, on calf muscle.
Calf muscles?
Yes.
Okay.
Calf muscle. And my lord, as per my lord, medical report, my lord, they say that moderately heavy weapon, my lord.
Moderately heavy weapon, moderately heavy
Yes.
weapon.
But my lord says, my lord, column katari, my lord.
Column cautery.
Yes, but that is knife, my lord. And this knife was also not sent for FSL, my lord.
Acha.
There is a blood, my lord, in knife.
No eyewitness to the injury.
It is my lord, father and my lord son, my lord.
Oh, Sanjay Urang killed his father with a dao. After his, person has died.
Yes, my lord, died, my lord.
So 4 years conviction.
Yes, my lord.
So on 301.
Lord, convert to 326, my lord.
Converted to 326. So converted to 326. Okay, yes. After receiving the FIR, the same was entered. The entry as Okay. So what else? Any specific paragraph of the judgment?
Yes, my lord. Page, my lord, 16, my lord. That is medical reports, my lord.
16.
Yes, my lord. Page 16 in my criminal.
Yes. Okay. PW5 is the doctor.
Yes, my lord.
Clean cuts incised wound on the cuff muscle of the
Yes,
right leg with clean cut of fibula. So this cannot lead to death of any person.
Yes, ma'am.
Then how did he die?
Yes, ma'am. I think
Because of bleeding?
yes.
Or what?
Because of bleeding, my lord.
Where is the
And
postmortem?
it's, my lord, shock. I think, my lord, shock. Due to shock, my lord, when
Ah.
blood is going, my lord, my lord, during, my lord, the father shock, my lord, and that, my lord. Then, my lord, police says, my lord, column Qatari, my lord. Page 18, my lord. That is, my lord, state. I was deposition, my lord. And my lord, this, my lord, weapon also not sent for FSL examination. And there is no eyewitness in this incident, my lord.
There are only 6 witnesses.
Yes, 6 witnesses. my lord. And my lord, kindly come. This, my lord.
Okay, right. Heard, Mr. J. Kohli.
Camp College.
M. Colita, learned counsel for the applicant, write it in the IA. Applicant and Miss S.H. Bora, learned APP for the state. By this application, the petitioner has prayed for suspension of sentence and bail to be granted to the applicant. Applicant, full stop. The applicant was convicted under section 326 IPC by the learned Session Judge Dibrugarh in Sessions case number 189 of 2022. By judgment dated 8/9/2025. Full stop. Thereafter, the applicant was heard on the sentence and by order on the same date, that is on 8/9/2025, sentenced the petitioner to undergo RI for a period of 4 years with fine and default stipulation. The case of the prosecution the case of the prosecution is that the applicant had killed his father with a dowry on 16/9/2019 at about 6 p.m. Full stop. The prosecution, during trial, the prosecution examined 6 witnesses. And after, there were no defense witness, right?
No defense.
And after examining the applicant under section 313 of the CRPC, convicted and sentenced the applicant as mentioned above. Full stop. The learned trial court had converted the case into 326 IPC and convicted and sentenced the applicant. Therefore, the learned counsel for the petition applicant submits that there is no eyewitness in the instant case. It was on circumstantial evidence.
Circumstantial evidence.
And the conviction was imposed upon the on the applicant on the basis of circumstances. The learned counsel submits that the medical report of the deceased father showed that there was only one clean-cut, incised wound on the cuff muscle of the right leg of the victim. Cuff muscles of the right leg of the victim. And that the victim died out of shock and as a result of bleeding. He further submits that charges under section 302 could not be established. Could not be established. And the conviction was given under section 326 of the IPC. He also submits that the sentence was for only 4 years and that the applicant had already stayed inside the jail for
13 months, 40 days.
13 months, 14 days. 40 days. And as such, he submits that during the pendency of the trial, the applicant be released on bail by suspending the sentence. Para. On the other hand, Ms. S.H. Bora, learned counsel for the state, submits that there are witnesses who had seen. Oh no, submits that
I'm relying on
the
PW1.
dying declaration submits that the victim had stated before the other witnesses that his son had cut him. And as such, he relies on the said dying declaration.
Also relying on the statement of PW1, PW6 or 5 and PW6 option.
Achha. She relied on the statement made by PW1,
5
5 and 6,
PW6.
which showed that the applicant has in fact attacked his father, and due to the said attack, the deceased died in the hospital.
And one column contrary kukri was recovered from the accused lordship.
From the possession of accused
From the
or what?
possession.
Column Kasari.
Where? From where? From it was.
He surrendered with column
He
Kasari.
surrendered before the police lordship.
She further submits that the applicant had surrendered with the weapon with which he attacked his father. That is a knife. Full stop. I have considered the submissions made by the learned counsels of the parties. And have gone through the records. It is in the evidence of PW number 1 that he heard the commotion in the house of the accused. And when he came to the house of the accused, he saw the deceased running out of his house, and that he fell down upon reaching the road. This witness saw bleeding in the legs of the deceased person. Acha, I said she relied on oral dying declaration will diva, huh? Jo dying declaration goes oral, huh?
Oral.
It is also stated by PW1 that when the deceased was brought home, deceased stated before him and others that applicant had attacked him. Full stop. It is a well-settled principle of law that in case of oral dying declaration, necessary corroboration is required. Which, however, has to be seen by a detailed study of the statement of the witnesses. And the same is not found prima facie in the evidence of this case. Be that as it may, since the applicant is sentenced with 4 years imprisonment by order dated 8/9/2025, this court deems it fit that the sentence be suspended and the applicant be released on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the session judge.
Dibrugarh.
Huh? Session judge, which place?
Dibrugarh.
Dibrugarh. I is disposed of. In the criminal appeal, you write? Lower court records heard Mr. M. Kolita, learned counsel for the appellant, and Ms. S.H. Bora, learned APP for the state. Case diary, the trial court records have been received. The matter be taken up for hearing in its usual course.
13 months, 40 days. That is, 14 months, 10 days.
Oh, now, till today.
Yes.
14 months, 10
10
days,
days.
diva.
That is
13
it.
months, kuslo na?
13 months, 40 days.
So,
So
40 days,
14
another month.
Oh, yes.
14 months, 10 days.
14 months, how many days? 10
10
days.
days.
14 months, 10 days, huh? Okay.
of last.
44 is what? Delay.
11.
Let the notice go today.
54 days.
54
Yeah,
days
appeared.
delay.
Have appeared.
Okay, you are appearing. For whom?
For respondent number 2.
Respond number 2 is what?
Lordship is a check bounce material.
Oh, it is check bounce.
There are financial implications.
Okay. So what about delay? Let it be delay. Condone?
Condone. Main case may be registered and
Okay.
showing my name this.
Heard, Mr. A. Khonikar, learned counsel for the applicant, and Mr. D.P. Goswami, learned APP for the state, and Mr.
BJ Mukherjee.
B.J. Mukherjee, learned counsel for respondent number 2. By this application, filed under Section 5 of the Limitation Act 1963, read with Rule 2, Rule 2 of Chapter 5A, Roman 5, 5 dash capital A of the Gauhati High Court rules. The the petitioner, the applicant has prayed for condoning the delay of 54 days in filing the connected criminal revision petition. The learned counsel for the applicant has placed the reasons for the said delay and has relied on paragraph 3 of the said application. Full stop. It is stated in paragraph 3. No, 2 and 3, right? Not 2.
2 and 3.
No,
The 3 one.
3. It is stated in paragraph 3 that after the judgment and order was pronounced on 24/9/2025, the applicant has applied for the certified copy of the said order, but the said certified copy was delivered to him on 17/10/2025 by his advocate. Full stop. Thereafter, the applicant states that he had suffered from sciatica pain and was under treatment, and that the doctor had advised him to take complete bed rest and to avoid traveling. Full stop. As per the advice of the doctor, it is stated that the applicant took bed rest from 15/12/2025 to 3/2/2026. And as such, he could not take steps for filing the criminal appeal or criminal revision petition. And when he recovered to a certain extent, he came down to Gauhati, met his advocate, and the revision petition was filed. Full stop. This court is satisfied with the grounds taken by the applicant for condoning the delay of 54 days. Accordingly, the delay is condoned. The registry is directed to register the connected criminal revision petition and list it for admission. The IA is disposed of.
Bring the name of my friend.
The IA is disposed of. There is another IA for leave. Or what? Oh no, same.
That is a statement.
Registry is further directed to reflect the name of Mr. B.J. Mukherjee in the criminal revision petition after it is registered and listed. Last reader. Yes.
Lordship, may kindly peruse the office note.
Service report.
Yes, Lordship.
The
Service is
tracking
already-
is done. Yes, report reflects that the item is delivered.
Yes, it is delivered a month back, Lordship.
Okay, then what is this matter about?
Lordship, this is for quashing of a cognizance taken against the accused person and for setting aside of the entire petition. Lordship.
Okay, let the amicus curiae be appointed then.
Lordship, however, I'd like to pray for a stay in this matter.
Okay, let the amicus curiae read the matter and we will consider on disposing. Why stay? Stay you should have got on the very first day itself.
The learned judge.
Now
of the
also
opinion-
respondent is not there. Then also represent. So now after 3-4 hearings, no stay. Okay, we will consider after, we can consider the entire case after amicus curiae is appointed. In the absence of respondent, it will not be fair, right?
Lordship, the stay may be given because the entire cognizance was taken without following the due procedure of law, without following the 223.
No,
and
that is what I'm
225.
saying. On the very first day, you should have got it.
Lordship, it was,
On the very first day, when a lawyer doesn't get a stay, then disposal. Or
In
on
that
the
case-
appearance of other party.
in that case, Lordship, may kindly take up the matter on a very short date.
Okay,
Because
I'll appoint an amicus because your service was complete.
on 23/6.
Complete was completed on 23/7. 27 is not long back.
Not
Right.
23/7.
Because tracking was done. And by tracking, it was found that
was
it was,
delivered
oh no, it was delivered on 23/6.
Yes.
So, okay, 1 month has gone, more than 1 month. So, let me appoint an amicus, dear. Okay. Heard Miss Begum, N. Begum, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. It is seen from the office note dated 23/7/2026 that service of notice upon respondent number 2. Respondent number 2 or who?
Respondent.
Ouch.
There is just one
Huh?
respondent.
Respondent or sole respondent? DP Goswami, you removed that name, huh? That sentence. Service of notice upon the sole respondent was complete on 23/6/2026, but till date, there is no representation on behalf of the said respondent. As such, this court deems it fit to appoint an amicus curiae to defend the cause of the sole respondent. Accordingly, Ms. Sri Aruna Fukan is appointed as the amicus curiae. The learned counsel for the petitioner should give the documents of the instant case to the learned amicus curiae at the earliest. List this matter on 5th of August, Wednesday, 5th of August, 2026.
Please,
46,
Lord.
yes.
For the suspension of sentence and bail, my lord. Because the
Acha.
POCSO by the co-appellant has already been granted by the court-led bench of honorable court. my lord.
Acha, counsel for the respondent is there.
Yes, sir, yeah, madam.
What is the sentence?
Sentence 10 years and 6 years respectively. The two.
10 years.
10 years. and
You have
6
filed your objection.
We have to find out when what option is. not
Objection, I
filed.
have other copy. The original file way back on 12/11/2025, my lord.
Oh,
Appellant has a
objection is
behind
filed.
for the
Wait.
396 days has been put in, madam.
But there is no objection here.
Well,
The copy of the objection is not here.
way back to 12/11.
On the last occasion, learned APP MP Goswami has prayed time to place his submissions against the bail prayer.
Submission.
Submissions, but 10 years, there has to be a written objection.
Yes.
And there is, if you have filed, it's not filed properly, it's not in the records.
My lord, co-appellant is already
It's not 10 years.
6 years and 10 years. Went through section 4 and 313 IPC. For a POCSO Act and as well as section 313 IPC, my lord.
Those sentences to run consecutively.
Consecutive.
Oh, consecutively. Otherwise, not 10-year sentence.
Yes, my lord. But the
As such.
co-appellant has two appellant. The co-appellant already granted bail by this honorable court.
Acha, where it is written that consecutively?
Nothing kindly said judgment starts from 29, my lord. 29 to 27. And to 68.
Main appeal.
Concurrently, madam. So, me kindly said page 64, my
Page
lord.
64.
Para
64
65.
Para 64 of the
of the main appeal.
Main appeal.
Main appeal.
Main appeal.
No,
Main
no,
appeal.
judgment, madam.
judgment.
What is the internal page?
Internal appeal.
In main appeal, my lord.
In the main appeal, what is the page?
Main appeal in the judgment itself. Yes,
81, from 81, madam.
What is the internal page? Tell me. Huh?
116.
What is the paragraph number?
Paragraph number
65.
64.
64.5. What is the paragraph number?
65, madam.
What's it?
Shall run concurrently, not consecutively.
Concurrently, madam.
So the written objection is not required.
Yes, madam.
Concurrently. So,
Right.
so what is the maximum sentence here?
10 years, madam.
How can it be 10 years?
6 years and
6 years and 10 years, madam.
What's it?
Where?
64, Lord, say para 64. Para 64 of
Two
the
wickets,
judgment, Lord, and main petition 116.
Paragraph 64. Oh, 10 years.
Yeah.
And to pay a fine. 4 only 10 years.
Yes,
Cost title is wrongly written over. Okay, 10 years. So bring your objection on record.
Lordship.
Okay. So, okay, heard, Mr.
Yes, go ahead, madam.
S. Gogoi, learned counsel for the applicant, and Mr. S. J. Sharma, learned counsel for respondent number 2. The Mr. D.P. Goswami, learned additional public prosecutor for the state, submits. What you have said, their objection is filed.
Well, earlier when it was filed, madam.
So I have to explain
Two
whether
appellant, madam. Actually, two appellant.
Two
Two
appellants.
appellant. The other appellant has been allowed on bail, madam.
Other appellant has been enlarged on bail.
By the court
And
judge,
this one, it was rejected.
Rejected.
So this is for the second time.
Second, yes.
Second time you have moved.
time.
The earlier order was on merits.
No, my lord, your lordship may kindly see the
on merits, Lordship.
on marriage
Is-
lordship of your lord, 70.
So how can you again raise the
No, but
question?
the law, on the law point, madam. New law point. Only the ground of law point, madam.
What law point?
Yes, delay, there is a control, delay of 1 year, lordship, if you see the lordship, the FIR, there's a 1 year delay without any explanation. FIR has been lost after 1 year of the alias occurrence. There is no
Okay,
offense.
file your act of the other case. Okay.
Okay.
Mr. D.P. Goswami, learned counsel, learned APP for the state, praised that he be given some time to file the written objection to the second bail application in respect of the appellant.
The directed on.
Prayer is allowed. List this matter on 17th of August 2026. Before that date, you file it, okay?
Yes, Lord.
Before the said date, the learned APP is directed to file the said written objection. 47. What is this? I in bail, disposed of bail
Yes, madam. Dispose of bill. Some,
by me.
Yes, yes.
Some mistake in the
Yes,
order.
yes, typographical mistake is there.
Where?
Lord, I have stated in my IA, page 3, para 4, 5, and 6. Regarding PS case number, it should be 94, but recorded at 24. Regarding one sections, 303 mentioned in the order, but the correct section 303 subsection 2. So, PS case number is,
These are the two.
my lord.
These are the two mistakes.
Yes, one mistake is there, my lord. That is a father's name of the petitioner, Abul Qasim instead of Abu Qasim. That is this total 3 mistakes.
Okay. Right in the application. Okay, this is an application for heard Mr. A.K. Azad, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has sought for correction of clerical / typographical error in the order dated 11/6/2026, passed in AB number 1074 of 2026. The learned counsel submits that in the said order, the number of the Gulabganj police station case number, the registration number, yes, the registration number of the Gulabganj police case was wrongly reflected as 94 of 2026, whereas the number should have been 24 of 2026, right?
No.
24.
24 is wrong, 94 is correct.
Oh, okay. 24 to agar diya, 94 to bisar diya. It was stated as 24, but it should have been 94
Hello.
of 2026. Full stop. The learned counsel also has pointed out that the penal provision related to the said case was jotted down as section 303 within bracket 3, but it should have been section 303 within bracket 2 of BNS 2023. Full stop. He also submits that the father's name of the petitioner number 2 was written as Abu Kashem, Abukashem, and the same should have been Abul, Abul, Kashem, Kahsem. Acha, so as far as the case number, it was written what? 24. 24. Golagans 24 in the first paragraph. Then in the last paragraph also. No, at only one point, right?
Yes, yes.
It is seen. It is seen that in the second paragraph of the order dated 11/6/2026, the case number written was Golagganj Police Station case number 24 of 26. However, the same should be Golagganj PS case number 94 of 2026. And the same 94 of 2026, full stop. Then as far as the penal provision mentioned in the said FIR was 303 within bracket 2, and in the said order and in the same paragraph, the penal provision was written as section 303 within bracket 3. Full stop. Further, the name of the father of the petitioner number 2 was written as Abu Kashem, and whereas by seeing the cause title, it should have been Abul Kashem. Para. As such, in the order dated 11/6/2026, in paragraph 2, the case number should be read as 94 of 2026, and the penal provision should be read as 303 within bracket 2, section 303 within bracket 2, and the name of the father of petitioner number 2 should be read as Abul Kasem. Read as Abul Kashem. The necessary corrections are made, and the present order will become a part of the order dated 15/6/2026. Oh, out of the order dated 11/6/2026. The IA is disposed of. Okay? Yes, Mr. Biswas, you have been sitting for so long. Yes, yes. I'm been calling you at the last hour of the day. What is this, Mr. Biswas?
I have challenged the warrant of arrest order on the first day.
Uh-huh.
The charge sheeted.
Huh.
I take you not 3 minutes.
Trial court records have been received.
Not received.
Not
But
received.
I've taken steps, madam.
But
No, trial court records will come from the court through
No,
the
it is not
registry.
the trial court not. It is a POCSO is added.
POCSO
That's
is
why
added.
I have made the party of the informant. That is requirement of law.
Acha, that is also not served.
That has not come, I think.
Acha, this is for quashing of FIR.
Pardon?
Quashing of FIR.
No. Well, quashing of the warrant of arrest order. There is a, please kindly peruse 28 page.
Okay, go. Let him go and appear.
A solicited case also we have in investment planning. So,
Well, charge sheet
another
is-
absconder.
I was shown absconder, and on the first day, my lord, non-bailable warrant was issued. That is under challenge.
Acha.
So, my lord, I am willing to appear.
But POCSO is there also. That is the problem.
Even then, my lord, I will appear, my lord.
POCSO is
As it
there,
is
but
a
then this is
protection-
not
Yes.
bail shale. This is he has to go and appear.
Yes, I
Only that on the very first day NBWA.
cannot. My lord, there are
There are decisions. No, there is a provision where NBWA can be issued. 82 or something.
My lord, latest
But there
judgment-
has to be regions.
latest judgment of our own High Court,
Hmm.
Pashupati Shukla
and Arjun Maji
Hmm.
has
10 minutes, not more.
Even?
It's only 10 minutes.
Tell me 5.
It's already past 5. Okay, but just show me the FIR.
At page 28.
28. So,
We are all employee of. Which runs a.
updated CD in the instant case is yet to be received.
Not, CD is not there, but CD is not necessary. Just look at.
But then there is a order by the court.
Page.
Now, by rejecting this, how can I just proceed? You bring the CD in a short date, Mr. Ring. Okay, heard Mr.
DK Agarwal.
D.K. Agarwal, learned counsel for the petitioner, and also heard Mr. D.P. Goswami, learned APP for the state. As ordered on the last occasion, the updated case diary is not yet received. And as such, Mr. D.P. Goswami makes a prayer to take up the matter on a later date. Prayer is allowed. List this matter on 6th of August, Thursday, 6th of August 2026. On which date, learned APP will place the case diary. Don't fail, huh? Okay, matters over. Okay, hello. I don't know.